Good morning. The second meeting of the 2024-2025 session of the Parliament of the Cayman Islands is now commenced. I'd ask the Honorable Attorney General to grace us with prayers.
Thank you. Good morning. Let us pray. Almighty God, from whom all wisdom and power are derived, we beseech thee so to direct and prosper the deliberations of the Parliament now assembled, that all things may be ordered upon the best and surest foundations for the glory of thy name and for the safety, honor, and welfare of the people of these islands. Bless our sovereign King Charles III, William, Prince of Wales, and all the royal family. Give grace to all who exercise authority in our Commonwealth, and peace and happiness, truth and justice, religion and piety may be established among us. Especially, we pray for the Governor of our islands, the Premier, the Speaker of the Parliament, the Leader of the Opposition, Ministers of the Cabinet, ex officio members, members of the Parliament, the Chief Justice, and members of the judiciary, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for thy great name's sake. Let us say the Lord's Prayer together. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. The Lord bless us and keep us. The Lord make his face shine upon us and be gracious unto us. The Lord lift up the light of his countenance upon us and give us peace, now and always. Amen.
Please be seated.
Administration of oaths or affirmations.
None.
Reading by the Honourable Speaker of messages and announcements.
None.
Presentation of petitions.
None.
Presentation of papers and of reports. Cayman Islands Government Unaudited Quarterly Financial Report, 9-month period ended 30 September 2024, Core Government. To be laid on the table by the Honourable Premier, Minister of Finance, Education, District Administration and Lands, Financial Services and Commerce and Health.
I recognize the Honourable Premier.
Thank you, Mr. Speaker, and good morning all. Mr. Speaker, I beg to lay on the table of this Honourable Parliament the Unaudited Quarterly Financial Report.
So ordered. Does the Honourable Premier wish to speak thereto?
Yes, thank you, Mr. Speaker.
Please proceed.
Thank you, Mr. Speaker. Mr. Speaker, on the 8th day of November 2024, the Ministry of Finance and Economic Development arranged for the gazettal of the Unaudited Quarterly Financial Report for a core government of the Cayman Islands for this period. The gazettal on the 8th of November satisfied the 6 weeks after the end of the quarter deadline specified in the said Act. The overview of the financial report for the 9 months period ended 30th of September 2024. Mr. Speaker, the information referred hereto is based on records obtained from the General Ledger of the government's financial management system. It is also based on the representations and judgments provided by the Chief Financial Officers of ministries, portfolios and officers, and of statutory authorities and government. Mr. Speaker, All of the amounts that I will provide from this point onwards are stated in Cayman Island dollars. The statement of the financial position as at the 30th of September 2024 on page 13 of the now tabled document shows that the core government ended the period with $3.3 billion in total assets, $1 billion in total liabilities, and therefore with $2.3 billion in net assets or net worth. Cash or cash equivalents, which includes fixed deposits with maturity durations not exceeding 90 days, were $138.1 million, and marketable securities, which are all comprised, Mr. Speaker, of fixed deposits with maturity durations exceeding 90 days, were $346.9 million, for a total of $485 million with respect to bank account balances. Due to the significant cash balances on hand, the government will continue to place funds on longer-term fixed deposits in order to maximize interest income for the government. These longer-term deposits are shown in the marketable securities on the Statement of Financial Position and are not included in the definition of cash or cash equivalent. That is a separate classification shown on the Statement of Financial Position, which is only representing the deposits that are 90 days or less to maturity. Mr. Speaker, the public debt for the core government stood at $420.9 million as of the 30th of September this year. This was $48.9 million less than the debt balance at the 30th last year, September. The debt balance continues to decline, Mr. Speaker, with the scheduled principal repayments being made. The government has not borrowed during this 9-month period and will resist doing so for as long as possible in the financial years. If revenues continue, Mr. Speaker, to do as well and expenditures are responsibly incurred, we will not borrow in 2024, although we are given the legal responsibility and empowerment to do so when the budget was approved last year. The Statement of Financial Performance for the period shown on page 7 of the document indicates that core government earned total operating revenue of $914 million and incurred total operating expenditure of $778.3 million. The resultant operating surplus for core government was $135.7 million. SAGCs posted a collective surplus of $12.9 million for the period, and thus the entire public sector had an operating surplus of $148.6 million for the said period. Or, Mr. Speaker, that equates to 35.1% ahead of the surplus projections for the period. Mr. Speaker, revenues recorded for the period were $914 million, were $27 million above our budget projections. This positive variance was mainly concentrated in the category of coercive revenue, which are revenues received by the government by virtue of coercive powers of certain specified acts. Coercive revenue was $7.3 million greater than what was budgeted for the period and $57.2 million greater for the period year to date with our actual revenues. Mr. Speaker, coercive revenue items performing better than budget expectations for those categories whose projected revenues were $5 million or more include financial services fees collected by the General Registry for Government. They were 14.2 more than budgeted. This category of revenues, such as company fees payable by exempt companies and partnership fees, were $7.4 million and $6.4 more than budget expectations, respectively. Property-related revenue, which were $12.9 million higher than was budgeted, includes revenues such as stamp duty, land transfer fees, which came in at 17.9 million positive variance and reflects an increase due to higher volumes of higher valued properties and transactions. And financial services fees, Mr. Speaker, collected by SEMA for government were $2.2 million higher than budget expectations, mainly due to an increase in the volume of registered funds. These positive variances from the budget expectations were partially offset by negative variance in other coercive revenue categories of coercive revenue, whose projected revenues were $5 million as such. Import duty revenues were $21.4 million less than what was budgeted for the projected period. However, Mr. Speaker, this category of revenue surpassed the same period as related to 2023 by $2.2 million. Other coercive revenues were $4.2 million less than budget projections for the period. The negative variance is mainly due to the commencement date for the Department of International Cooperation, filing fees being deferred from 2024 to 2025. Mr. Speaker, expenses incurred for the period of $778.3 million were $10.9 million less than a year-to-date budget of $789.2 million. The largest overspends were in the categories of output from SAGCs, a negative variance of $14.4 million. Outputs from non-governmental output suppliers, a negative variance of $12.1 million, and transfer payments, a negative variance of $11.2 million. These overspends were offset by savings, Mr. Speaker, in personnel costs, a positive variance of $34.4 million, and supplies and consumables, a positive variance of $11.5 million. Mr. Speaker, with respect to expenditures, the extent of an underspend or overspent is calculated by comparing the actual expenditures to the initial budgeted amounts in the 2024 financial year. And honourable members, Mr. Speaker, will be cognizant that the initial budget for 2024 financial year was approved by Parliament on the 15th of December last year. Mr. Speaker, it is, however, important that I make it explicitly clear that although I have spoken of budgets being overspent, this is by reference to the initial budget for 2024 financial year, which was passed in December last year. Government has obtained the required approvals to spend levels greater than the budgeted amounts. With such approvals come in via Cabinet, either through 11.5s of the Act or through Section 12s that come to Finance Committee in 2024. So there's a proper authority, Mr. Speaker, for the incurrence of the amounts that I in here to mention, which led to the description of overspending, because that description relates to a position that has been superseded by changes made during 2024. Mr. Speaker, costs relating to personnel for the period amounted $341 million, which reflects an underspend in personnel costs by $34.4 million, which is 9.2% less than the budgeted projection of $375.4 million for the said period. This favorable variance is a result of several ministries and portfolios having vacant posts, which to the 30th of September this year remained unfilled. Actual expenditures on surplus and consumables were also lower than projected, Mr. Speaker, with an underspend of $10.6 million, which is 9.4% less than the budgeted projection of $122.2 million for the corresponding period. Within the supplies and consumables category, Mr. Speaker, the most significant underspend related to the purchase of services, which accounts for the majority of positive variance in the consumables and supplies classification. Outputs from SAGCs of $148.7 million were $14.4 million, or 10.7% more than the year-to-date budget of $134.3 million. Outputs from non-governmental suppliers of 54.9 million were 22.1 million, or 67.3% more than a year-to-date budget of 32.8 million, mainly due to the NGS 55 tertiary care at local and overseas institutions. The costs for NGS 55 are currently at 38.5 million and exceeds the 2024 initial full budget of 19.9 million. Transfer payments of 61.1 million were 11.2 million, or 22.4% more than the budget for the period. This variance, Mr. Speaker, is mainly due to the overages in financial assistance, offset by savings in other expenditure areas. The statement of cash flows on page 18 of the table document shows that the next cash inflows from operating activities total $105.1 million. The net cash outflow from investing activities during the period was $17.2 million, whilst the cash outflow arising from financing activities was $57.8 million. Investing activities included in the $591.5 million, Mr. Speaker, placed on fixed deposits. Additionally, $86.9 million was utilized for capital investment and expenditures relating to purchase of property, plant, and equipment, $64.5 million, and equity investment in SAGCs of $22.4 million. In conclusion, Mr. Speaker, the overall fiscal performance reported for the period shows a core government operating surplus of $135.7 million, which is $38 million, or 38.8% greater than the budgeted expectations for the said period. The SAGCs contributed a combined surplus for the period of $12.9 million, exceeding the estimated results for the third quarter of 2024 by $14.2 million, which meant that when the surplus from the SAGCs is combined with the core government surplus, the entire public sector achieved a surplus of $148.6 million, or 54% ahead of the EPS surplus projections for the said corresponding period. The government's cash position, Mr. Speaker, ended at $485 million for the period. $197.1 million were held in reserve and restricted deposits. $287.9 million were operating bank account balances. Mr. Speaker, I am therefore pleased with the government's financial performance for the 9 months ended 30th of September this year. The third quarter 2024 performance has placed the government in a most favorable position for the remainder of the year. We are well aware, Mr. Speaker, that continued fiscal discipline and ongoing monitoring of public finances are absolutely critical and necessary, and that has been the modus operandi. The unaudited quarterly financial report for the core government of the Cayman Islands for the 9-month period ended 30th day of September 2024 is available on the Minister of Finance and Economics website, www.gov.ky/finance, and it has also been gazetted, Mr. Speaker, on the 8th of November 2024. Thank you, Mr. Speaker.
Ministry of Financial Services and Commerce, Cayman Islands Government, Annual Report 2023. To be laid on the table by the Honourable Premier, Minister of Finance, Education, District Administration and Lands, Financial Services and Commerce, and Health.
I recognize the Honourable Premier.
Thank you, Mr. Speaker. Mr. Speaker, I beg to lay on the table of this Honourable Parliament the Annual Report 2023 for the Minister of Financial Services and Commerce.
So ordered. Does the Honourable Premier wish to speak thereto?
Yes, thank you, Mr. Speaker.
Please proceed.
Mr. Speaker, I am pleased to present the annual report for the Minister of Financial Services and Commerce This annual report includes details outlined in the financial statement, as well as information on the activities and accomplishments of the Ministry for 2023 financial year. Components of the financial statement. Mr. Speaker, the audited financial statements for the Ministry of Financial Services and Commerce are comprised in the Statement of Financial Position, the Statement of Financial Performance, the Statement of Changes in the Net Worth, and a Statement of Cash Flows, and the notes of the financial statement. Mr. Speaker, the Statement of Financial Performance shows that the total revenue earned by the Ministry during the period was $21.5 million, and total expenses was $21.5 million. The Ministry ended the 2023 financial year with $24.9 million in total assets, $2.9 million in total liabilities, and total net assets of $22.2 million. Cash and cash equivalents held by the Ministry as of the 31st of December 2023 were $22 million. Achievements. Mr. Speaker, the following are some of the key highlights of the activities and accomplishments of the Ministry during 2023 financial year. The Ministry and its agencies greatly contributed to the Cayman Islands' removal from the FATF grey list in October 2023, when the FATF determined that the Cayman Islands AML CFT regime met global standards. The Washington, D.C. office of the Cayman Islands government was officially opened in January last year, which then facilitated an increased level of engagement with the U.S. officials throughout the year. In September, Mr. Speaker, the Cabinet approved the establishment of an office in Asia, which would go on to increase engagement with the financial service industry in the region. In April, as a part of the celebrations leading up to the World Intellectual Property Day, the Cayman Islands Intellectual Property Office recognized the creativity and the entrepreneurial spirit of Susan Soto, the creator of the Sir Turtle trademark, which was the first trademark on the government's register when direct registration started in 2017. Mr. Speaker, the General Registry launched a new user-friendly vital event system that allows online submission from stakeholders from hospitals, funeral homes, and marriage officers. Efforts to support our local financial services industry also resulted in the development and passage of 13 acts, 10 regulations, including the Beneficial Ownership Transparency Act, which was a consolidation of Cayman's beneficial ownership legislation that also improved Cayman's framework for transparency and alignment with global standards. Auditor General's opinion, Mr. Speaker, issued an unqualified opinion on the financial statements of the Ministry for Financial Services and Commerce for the year ending the 1st of January 2023 and ended on the 31st of December 2023. In conclusion, Mr. Speaker, 2023 was undoubtedly a year of significant milestones and accomplishment, and I wish to go on record to thank the former Minister for Financial Services and his team, both ably led by himself and Dr. Dak Bastillo. I would like to thank, in addition to the Chief Officer, his senior leadership team in the Ministry and the heads of all agencies for their dedication, commitment, as well as our Honourable Attorney General for they worked assiduously to ensure that Cabinet were placed in a position to bring forward the various acts, as well as to pass expeditiously, oftentimes with much haste, but full consideration, the regulations. And so, Mr. Speaker, it goes without saying that it takes two hands to clap, and so I gladly wish to convey and put on record my sincere appreciation to the former Minister, my former Cabinet colleagues, and entire Cabinet, and the civil service, without which these could not have been accomplished. I thank you.
Beneficial Ownership Transparency, Legitimate Interest Access Regulations 2024. To be laid on the table by the Honourable Premier, Minister of Finance, Education, District Administration and Lands, Financial Services and Commerce, and Health.
I recognize the Honourable Premier.
Thank you, Mr. Speaker. Mr. Speaker, I beg to lay on the floor of this honourable Parliament the beneficial ownership, transparency, legitimate interest, access regulations 2024.
I believe you meant the table, not the floor. So ordered.
On the table, which is sustained by the floor. Thank you.
Does the Honourable Premier wish to speak thereto?
No, thank you, Mr. Speaker, as there is a corresponding government motion that will feature on Wednesday.
Very well.
Report and recommendation of the Minister responsible for lands on the vesting of Crown land at Registration Section West Bay Beach South, Block 13B, Parcel 103H16 to Logwood Estates Limited. To be laid on the table by the Honourable Premier, Minister of Finance, Education, District Administration and Lands, Financial Services and Commerce, and Health.
I recognize the Honourable Premier.
Thank you, Mr. Speaker. Mr. Speaker, I beg to lay on the table of this honourable Parliament the report and recommendation of the Minister responsible for lands for the Government Vesting of Lands Act 2025 as it relates to the Logwood Estate Limited.
Does the Honourable Premier wish to speak thereto?
Yes, thank you, Mr. Speaker.
Please proceed.
Mr. Speaker, Block 13B reflects a disposition of a sale of surplus property asset that recently became vested in the Crown under the provisions of the Company Act. Mr. Speaker, 13B parcel 103H16 comprises of residential 2-bedroom, 2-bathroom condominium with a floor area of 1,228 square feet in a strata development known as the Grape Tree, located on Snooze Lane off West Bay Road in Georgetown, Grand Cayman. The Grape Tree condominiums were constructed around 1980 and reliably informed, and Block 13B, Parcel 103, is the mother parcel registered to the proprietors of Strata Plan number 35 and is zoned hotel residential. Mr. Speaker, if I may provide some background, the property was first registered to a company called Diversified Manufacturing Systems in 2003. However, this company was struck off by the Register of Companies on the 31st of December 2009 on the statutory grounds that the registrar had reasonable cause to believe that the company was not carrying on business or in operation. Section 156, Part 4 of the Companies Act 2023 revision, Mr. Speaker, this action is automatically taken by the registrar with any qualifying company when annual company registration fees are not paid. Section 162 of the said Act states, and I quote, any property vested in or belonging to any company struck off the registrar under this law shall thereupon vest in the minister charged with the responsibility for finance and shall be subject to disposition by the Cabinet or to the retention for the benefits of the islands, unquote. Therefore, Mr. Speaker, ownership of the property automatically became vested in the Crown after the company had been struck off for in excess of 10 years. This being the term of years after which a defunct company becomes legally incapable of reinstatement under the Act. Mr. Speaker, in 2022, the Cabinet then decided that the vacant property was surplus to the requirements and should be sold. 3 valuations of the land to be transferred are required under the Governor Vesting of Lands Act 2005 revision, 1 from the Government Chief Valuation Officer and 2 from independent property valuation companies. In this instance, 4 opinions were obtained. The 4 opinions of market value were as follows. Lanson Survey, 700,000. DDL, 705,000. Quayside, 789,000. and BCQS 785,000. Accordingly, Mr. Speaker, in 2022, the Lands and Survey Department conducted a public tender exercise inviting sealed offers by a deadline. However, the highest bid received was below the market value, and so Cabinet decided not to accept any of the offers received. Cabinet decided that the property be remarketed by a professional real estate agent. In 2023, the department undertook a competitive procurement exercise of realtors registered in the Cayman Islands Real Estate Brokers Association. Mr. Speaker, the highest point scorer was a realtor, Ms. Amber Yates of Century 21. Ms. Yates was appointed in 2023 and widely marketed the property at a listing price of $970,000. In August 2024, a bid of $805,000 were submitted by a company called Logwood Estates Limited. The offer was made and government accepted. The Chief Valuation Officer recommended this acceptance to the said offer. Mr. Speaker, after careful analysis and consideration of the report provided, Cabinet resolved on CP 486/24 on the 2nd of October this year to advise Her Excellency the Governor to approve the sale of Crown Land Block 13B, parcel 103H16 to Logwood Estates for a consideration of $805,000 Cayman Islands dollars. The Cabinet did not waive the stamp duty due on the transfer. The Realtor Sales Commission from Sariba was 6% applicable to this sale value, and it will be deducted from the sales proceeds. Mr. Speaker, I confirm that as required by the Act, the details of this proposed land disposition have been published in the Cayman Islands Gazette on the 18th of October this year and in a local newspaper, namely the Caymanian Times, on the 13th of November. Accompanying this report are all of the required documents as specified in Section 10.2 of the Governor's Vesting of Lands Act 2005 revision, including the valuation reports. Mr. Speaker, I therefore respectfully ask that this report be accepted as laid.
Report and recommendation of the Minister responsible for lands on the vesting of Crown land at registration section West Bay Beach North, Block 11C, Parcel 70, to Anthony Ashmore, to be laid on the table by the Honourable Premier, Minister of Finance, Education, District Administration and Lands, Financial Services and Commerce, and Health.
I recognize the Honourable Premier.
Thank you, Mr. Speaker. Mr. Speaker, I beg to lay on the table of this Honourable Parliament the Government Vesting Lands Act in accordance with that, the report and recommendation as laid by me for parcel Block 11C, parcel 90, to an Anthony Ashmore.
So,
let me say that again, Mr. Speaker. West Bay, section Beach North, Block 11C, parcel 70, to Anthony Ashmore.
so ordered. Does the Honourable Premier wish to speak there too?
Yes, thank you, Mr. Speaker. Mr. Speaker, Block 11C, parcel 70, comprises of a small rectangular-shaped, undeveloped parcel of Crown land located by the roundabout at the junction of Esther Tibbetts Highway. Its registered area is 0.0459 of an acre of 1,999 square feet. The unusual configuration of parcels 70, Mr. Speaker, and similar adjacent small parcels derived from land mutation undertaken in 1976. The zoning is low-density residential. Mr. Speaker, Block 11C, Parcel 3, registered to Mr. Anthony Ashmore, adjoins Parcel 70 on its south side. Its registered area is also 0.0459 of an acre, or 1,999 square feet. Mr. Speaker, the Crown's ownership of 11C, Parcel 70, derives from an initial land swap exercise that was undertaken in 2023, whereby a third party and the Crown exchanged isolated parcels in the same subdivision to the mutual benefit of both parties, resulting in land holding configurations. Mr. Speaker, Phase 2 of this land reconfiguration exercise is for the Crown and Mr. Ashmore to exchange parcel 70 and parcel 3. Once this exchange is duly completed, the Crown will now own 5 contiguous small parcels here, and Mr. Ashmore will own 2 contiguous small parcels. It is in both parties' interest to undertake the said exchange, since it will result in both parties owning more valuable contiguous land holdings capable of development. At present, the parcels are separate and subsidized for development in isolation, with values being low as a result. Mr. Speaker, the Crown approached Mr. Ashmore to propose the mutually beneficial land exchange for parcel 70 for 3. Mr. Ashmore agreed, provided the government undertakes a slight realignment of the mutual parcel boundary by way of reparcellation. This is deemed acceptable and does not affect the area of either parcel. Mr. Speaker, 3 valuations of the land to be exchanged are required under the Governor's Vesting of Lands Act 2005 revision, 1 from the government, Chief Valuation Officer, 2 from independent property valuation companies. The table, which I'm about to explain, outlines 3 opinions of market values of the lands being exchanged. Although this is an academic exercise, since no money is changing hands, it is to be straightforward, nil consideration land swap exchange. Lands and Survey came in at 31,000, Bowl at 21,000, and Plum at 50,000. That was parcel 70 and parcel 3. Lands and Survey came in at 31,000, Bowl at 28,000, and Plum at 50,000. After careful analysis and due consideration, Mr. Speaker, of the report provided, Cabinet resolved in Cabinet Paper 293/24, dated the 11th of June this year, to advise Her Excellency the Governor to approve the land swap, that is the disposal of Crown Land 11C parcel 70 to Anthony Ashmore in exchange for Mr. Ashmore's block parcel 11C, block 11C parcel 3, stamp duty to be waived and the Crown to bear the cost of the reparcellation. Mr. Speaker, I confirm that as required by the Act, that the necessary details of this proposed land disposition have been published in the Cayman Islands Gazette on the 18th of October this year, and a local newspaper, namely the Caymanian Times, on the 13th of November this year. Accompanying this report, Mr. Speaker, are all of the necessary and required documents as specified in Section 10.2 of the Governor Vesting of Lands Act 2005 revision, including the valuation reports. Mr. Speaker, I respectfully ask for the House to accept the report as duly laid and explained.
Very well.
All right. Cayman Port. The Annual Report 2023, Port Authority of the Cayman Islands, to be laid on the table by the Honourable Deputy Premier, Minister of Tourism and Ports and Social Development and Innovation.
I recognize the Honourable Deputy Premier.
Thank you, Mr. Speaker. I rise to lay on the floor on the table of this Honourable House the Annual Report 2023, Port Authority of the Cayman Islands.
So ordered. Does the Honourable Deputy Premier wish to speak thereto?
Very quickly, Mr. Speaker, just to say that the report has received an unqualified opinion by the Auditor General on the port's financial statements and has made a surplus for the year 2023, also with an increase of 3% from the previous year of 2022. I encourage all members of this Honourable House to peruse the report with the successes the port is doing. Thank you.
Very well.
Public Service Pensions Board 2023 Annual Report and Accounts, to be laid on the table by the Honourable Deputy Governor, ex officio member, responsible for the portfolio of the Civil Service.
I recognize the Honourable Deputy Governor.
Thank you, Mr. Speaker. Mr. Speaker, I beg to lay on the table of this Honourable House the 2023 annual report and accounts for the Public Service Pension Board.
So ordered. Does the Honorable Deputy Governor wish to speak thereto?
Yes, Mr. Speaker, just briefly. Mr. Speaker, this past year presented new challenges following a period of unique circumstances resulting from rapid inflation. Increasing plan member expectations and having to continue to prove that stakeholder confidence in the Public Service Pension Board continues to be well-founded. Throughout 2023, the Board of Directors, the management team, and staff demonstrated their ability to innovate during these new times and to deliver even when they had to operate with fewer key personnel. When we review 2023, it again shows the authority at all levels work to deliver on their mission of excellence in member services. Mr. Speaker, as the pension leader in the Cayman Islands, the Public Service Pension Fund continues to be the standard, and as of 31st of December 2023, the market value of the fund was 1.134 billion Cayman Islands dollars. This was achieved through sound management of the fund and an exceptional return, Mr. Speaker, of 19% for the fund for the year. It was this return that ranked the Public Service Pension Board in the top 1 percentile of the peer group for performance in the year. And I think, Mr. Speaker, that deserves commendation to the board, the CEO, and the entire team at the Public Service Pension Board. They continue to make us proud in their management of our pension fund. Mr. Speaker, in addition to those outstanding achievements, the Auditor General gave the accounts an unqualified opinion, and I think we should go on record and thank the board and the CEO, Ms. Jewel Evans-Lindsay, and her team for their outstanding performance in 2023. I thank you, sir.
Very well.
Questions to honourable ministers and members of the Cabinet.
No answers have been received.
Statements by honourable ministers and members of the Cabinet.
None.
Personal explanations.
None.
Obituary and other ceremonial speeches.
None.
Raising of matters of privileges.
None.
Government business bills. Banks, first readings. Banks and Trust Companies Amendment Bill 2024.
One moment, Madam Clerk. Madam Clerk, would you read the title again for me, please?
Banks and Trust Companies Amendment Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Companies Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Companies Management Amendment Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Exempted Limited Partnership Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Insurance Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Limited Liability Companies Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Limited Liability Partnership Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Monetary Authority Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Mutual Funds Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Partnership Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Private Funds Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Securities Investment Business Amendment and Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Virtual Asset Service Providers Amendment Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Information and Communications Technology Validation Bill 2024.
The bill is deemed to have been read a first time and is set down for second reading.
Second readings. Banks and Trust Companies Amendment Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. I beg to move the second reading of a bill entitled the Banks and Trust Companies Amendment Bill 2004.
The bill has been duly moved. Does the Honorable Premier and Minister of Financial Services wish to speak thereto?
Thank you, Mr. Speaker. Mr. Speaker, I rise to present the bill on behalf of the government. It's a bill that seeks to amend the Bank and Trust Company Act 2021 revision, known as the Principal Act, to provide that the application fee for the grant of a license is non-refundable and for incidental and connected purposes. The reasons for the bill, Mr. Speaker, this section is copied and included in all fee-related speaker notes, Mr. Speaker, so it may seem repetitive, but they're similar in their operation. So in the interest of time, I will just read it for this bill based on your kind indulgence and permission, and not repeat it in all of the other consequential bills. Thank you. Mr. Speaker, this bill is also part of a comprehensive review of fees which the Ministry has undertaken, and the same background as previously stated applies to this bill as well. So again, in the interest of the time, I'll refer to the explanations in one bill and will indicate it as I move along. Mr. Speaker, the administrative and regulatory fees form an integral part of the government's general revenue. Fees charged by the General Registry and the Cayman Islands Monetary Authority, CIMA, typically account for nearly a third of the government's total revenue income. These fees are generally charged for the provision of a service. They help bring in needed revenue for government programs, and most importantly, Mr. Speaker, they serve to cover costs incurred for the provision of the said services. Mr. Speaker, our fee structure is such that there is no automatic method by which the fees charged are regularly reviewed. They are set either within primary legislation, within schedules, or by secondary legislation known as regulations. The Ministry of Financial Services and Commerce, the Ministry, initiated a general review of all the fees being charged by the Registry and CIMA in 2023. This review has identified that a wide majority of the regulatory or administrative fees have not been reviewed in 5, 10, or in some cases, 15 years. Mr. Speaker, the cost incurred by the Registry and CIMA for the services they provide have increased steadily over the past 10 years in line with inflationary forces, the implementation of new global standards, and the implementation of new systems and personnel. The Ministry has identified that the fees currently being levied have not kept up with these increasing expenditures and are due for revision. The Ministry is aware of the deep impact of an increase in administrative and regulatory fees may have on our financial services industry. For this reason, the Ministry engaged extremely closely with the Registrar, CIMA, and industry stakeholders in preparing the legislation that we'll see here today. The Ministry also engaged with 2 consultants, with heads of industry association, their members, with the proposed fees in accordance with proper policy development procedures, and revisited certain fees based on feedback that the Ministry received. Mr. Speaker, this amendment to the Banks and Trust Company Act forming part of a legislative package, ensures that the fee measures as contemplated for 2024-2025 are appropriately provided for in legislation. It also ensures, Mr. Speaker, the sustainability of the registers and CEMA's future activities, including providing services and applying fees. Validation provisions are also included in certain bills to ensure that services provided by the said register and CEMA are supported by in primary legislation. The summary of the bill, Mr. Speaker, it provides that the application fee for the grant of a license is non-refundable. Clauses, the bill is arranged in 4 clauses. Clause 1 provides a short title and the commencement of the said legislation. Clause 2 amends Section 6 of the Principal Act to improve on the paragraphing of the provision in keeping with the modern legislative drafting practices. Clause 3, Mr. Speaker, amends Section 27(1)(a) of the Principal Act to adjust the cross-references to Section 6(1). This is as a consequence of the amendments to Section 6 of the Principal Act. Clause 4, Mr. Speaker, provides the transitional arrangement for applications for which a decision is pending on the day immediately preceding the commencement of this amending act. The application fee for those applications will be refundable. In conclusion, Mr. Speaker, I wish to thank the Ministry staff and the Legislative Drafting Department for their efforts with respect to the design and preparation of the bill, as well as the former Minister and members of the House for their anticipated support, members of Cabinet, as well as the Parliamentary Secretaries. I look forward as I commend the Bank and Trust Companies Amendment Bill to this Honourable House for its second reading, and also wish to convey my very sincere and deep gratitude to the official members of the opposition for agreeing up front to form a quorum for the House so that these important legislative acts can see safe passage and we can continue with the longevity, sustainability of the finances within this jurisdiction. I therefore commend the Banks and Trust Companies Amendment Act 2024 to this Honourable House for its second reading, and would ask that all members support it. I wish also to thank the member from Bodentown South, I believe it is. West, I beg your pardon. For the avoidance of doubt, even though it's against the rule, I'll actually indulge in Mr. Chris Saunders for his support in these financial bills as well. And Mr. Speaker, although I did not directly hear for the member from Savannah, I know based on his background and indications that had he not supported it, he would have expressed it. So I wish to also convey my gratitude for his support of these bills for the member from Savannah. Thank you. Newlands. That's a Freudian slip, but I'm sure the same goes for the member from Savannah.
Thank you, Madam Premier. Does any other member wish to speak? Does any other member wish to speak? The Honourable Member for West Bay South. I got to get used to these new, this new nomenclature.
Good morning, and thank you, Mr. Speaker. I rise to support the Banks and Trust Companies Amendment Bill 2024. I wholeheartedly like to thank the Ministry, Legislative Council for their hard work on this bill and the others. Myself, the member for West Bay Central, the member for Prospect, the member for Savannah, and the member for Newlands. Although these did not meet the 28-day notice period, we could see the urgency and had no difficulty in accepting them, Mr. Speaker, for planned, which will assist in the raising of revenue for planned expenditure in 2025. As the Premier mentioned in her contribution, there was a very comprehensive fee review of all monetary authority license fees and general registry fees, which had significant industry consultation. I think industry, for the most part, as far as I can recall, were at least willing to accept the fee increases for the reasons that the Premier outlined. I do recall that the Class A banks may have had some consternation about their proposed fee increases, and I wonder whether the Honorable Premier, in her right of reply, may be able to update the House and the public as to the fees that will be charged to Class A banks, as I believe I haven't seen regulations posted to that effect, because I believe they would form part of secondary legislation on the Gazette website, and those fees, I believe, will fall due to SEMA as of 1 January of next year. With that, Mr. Speaker, we support the bill and commend all involved for their contributions and hard work. Thank you, Mr. Speaker.
Thank you. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I'll invite the Honorable Premier to exercise her right of reply.
Thank you, Mr. Speaker. I wish to thank the member from West Bay South for his contribution, and it begs the reply on two particular points. Firstly, yes, the bill did not meet the 28 days, but by virtue of Section 77 of the Constitution, which, Mr. Speaker, you're more than familiar with, there is a provision in the case of emergency where the proposed change would be required the Premier to signify that the bill is too urgent to permit the 28 days. And I did write when I was in London on the other business a couple of weeks ago to your good self, indicating that I would be utilizing Section 77 of the Constitution for these very important pieces of legislation. And secondly, I am reliably informed by the very able and capable Dr. Daxey, Chief Officer, that there are no changes for the Class A license and fees at this time. Other bank fees will be raised. Thank you, Mr. Speaker.
Thank you, Madam Premier. And for the record, I wish to confirm that the Premier wrote to me as Speaker, certifying under Section 77(2) of the Constitution that these bills, that is all of the financial services bills, required to be passed at this meeting and would not meet the 28-day requirement, but due to the importance and urgency of having these passed, she was invoking said section, which is what the Constitution requires. Those in favor of the Banks and Trusts Companies Amendment Bill 2024, please say aye.
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 Those against, no. The ayes have it. The Banks and Trust Companies Amendment Bill 2024 has received a second reading.
Companies Amendment and Validation Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled the Companies Amendment Validation Bill 2024.
Very well. Does the Honorable Premier and Minister of Financial Services wish to speak thereto?
Yes, thank you, Mr. Speaker. Mr. Speaker, I rise once again to present the bill on behalf of the government. It is a bill that seeks to amend the Companies Act 2023 revision to provide for the application for name reservation, to provide for the charging of fees for administrative services, to expand the list of transactions in respect of which express fees may be paid, to validate certain revenue collection actions of the registrar, and for incidental and connected purposes. Mr. Speaker, administrative and regulatory fees form an integral part of any government's revenue, and so fees charged by the General Registry and the Cayman Islands Monetary Authority, CIMA, typically account for nearly a third of the government's total revenue. These fees are generally charged for the provision of the various services. They help bring in needed revenue, and most importantly, because of financial services being such an important role player for our revenue, it covers the costs necessary for the provision of these services. Our fee structure is such that there is no automatic way to raise them, and so we have to bring them as we bring in today and set primary legislation, some cases within schedules or by secondary regulations such as legislation such as regulation. Mr. Speaker, the Minister of Financial Services and Commerce, as I said, did a review back in 2023, and this is one of them that we found that needed to be amended. Mr. Speaker, the costs incurred by the Registrar and CIMA for the services they provide have increased steadily over the past 10 years, and in line with inflationary forces, the implementation of new global standards, which required much more HR, and the implementation of new systems together with this personnel. The ministry has identified that the fees currently being levied certainly have not kept up with the increase in expenses and are due for the revision. The ministry is aware of course, any increase will have an impact, and for this reason, the necessary due diligence was done, where consultation and collaboration was engaged with CIMA, the registrar, industrial stakeholders. They also engaged, as I indicated, with 2 consultants, with heads of the Industry Association and members. We now have the proposed fees in accordance with the proper policy development and procedures, revised certain fees based on the feedback that was received. Mr. Speaker, the amendment to the Companies Act, which forms part of the legislative package, will ensure that our fee measures as contemplated for 2024-2025 budget are appropriately provided for in legislation. It also ensures the sustainability of continued revenue for the registrar and for CIMA futures activities, including the provision of these services and applying fees. The validation provisions are included in certain bills to ensure that the fees that are charged by the registrar and CIMA are in fact and indeed supported by the primary legislation. Mr. Speaker, the bill provides for applications for name reservations, to provide for the charging of fees for administrative services, to increase express fees, and to expand the list of transactions in respect for which express fees may be paid. The bill also validates certain revenue collection actions of the registrar before the commencement of this said legislation, and it provides for incidental and connected purposes. Mr. Speaker, the bill is arranged into 9 clauses. Clause 1, of course, provides for the short title and the commencement of the legislation. Clause 2 amends the Principal Act by inserting a proposed Section 29A. The proposed Section 29A, Mr. Speaker, provides for the making of applications to the registrar to reserve a specified name for a company up to a period of 4 months. Clause 3 amends the Principal Act by repealing and substituting Section 159. The substituted Section 159, Mr. Speaker, provides, among other things, that before the name of a company may be restored to the register, the company shall pay a reinstatement fee equivalent to 2 times the original incorporation or registration fee. Clause 4 amends the Principal Act by inserting a proposed Section 199A. This proposed section, Mr. Speaker, being 199A, provides for the payment of prescribed fees to the registrar in respect of prescribed administrative services, set out in Part A of this Schedule 5. Clause 5, then, Mr. Speaker, amends the Principal Act by repealing and substituting Section 200. The substituted Section 200 provides for additional categories of transactions which may be expedited upon the payment of an express fee, and to increase the express fees in respect to existing transactions. Clause 6 amends Section 283 of the Principal Act to provide, among other things, that regulations that are made by Cabinet under the legislation may prescribe any fees payable under the legislation. Clause 7, Mr. Speaker, amends Schedule 5 of the Principal Act to introduce fees for an application to the registrar to reserve a specified name for a company as a consequence of the insertion of the proposed Section 29A. The clause also amends Schedule 5 of the Principal Act by inserting Parts 8 and 9. The proposed Part 8 sets out the administrative services which may be provided and their corresponding fees. The proposed Part 9 sets out the various transactions in respect which express fees may be charged and specifies the respective amounts of the express fees. Clause 8, Mr. Speaker, deals with the validation of fees collected without statutory authority by the registrar, where those fees were charged and collected prior to the commencement of this amending and validating legislation. This clause seeks to validate the collection of those fees by the registrar as if the registrar was empowered to do so under this amending and validating legislation. Clause 9, Mr. Speaker, provides for this amending and validating legislation that it does not affect any order or determination made by a court relating to fees collected by the registrar without statutory authority for any service provided by the registrar before the commencement of an amending and validating legislation. In conclusion, Mr. Speaker, I wish to thank once again the Minister's staff, the former Minister for Financial Services, the Legislative Drafting Department for all of their efforts in respect to the design and preparation of the bill. I therefore, Mr. Speaker, commend the Companies Amendment Validations Bill 2024 to this Honourable House for its second sitting and look forward to the full support of the House.
Thank you, Madam Premier. Does any other member wish to speak? Does any other member wish to speak? The Honourable Member for West Bay South.
Thank you, Mr. Speaker, and thank you to the Premier and the government for bringing the Companies Amendment and Validation Bill 2024. I only have one brief question that I wonder whether the Honourable Premier could address in her right of reply, in that I believe, if I heard the Honourable Premier correctly, in her statement in relation to the unaudited financial report for the 9-month period ended 30 December 2024 was the deferring of the proposed Department of International Tax Cooperation fees, which did not come about in 2024 based on industry consultation that the manner in which they were first proposed would have been difficult or challenging for that department to collect, since historically it had not collected fees in the past, but the industry group advised that a more efficient way to collect the same fee would be through the raising of specific company administrative fees. So my question is whether or not, by secondary regulation or otherwise, will those fees now be collected so that that would assist with the budget, which was supposed to be for the Department of International Tax Cooperation, because I believe the projected raise was north of 10 million or even north of $12 million. Other than that, thank you to the government, and thank you for all involved who participated in the design and the completion of this bill. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I'll invite the Honourable Premier to exercise her right of reply.
Thank you, Mr. Speaker. Only to thank members again for their tacit support and for the former minister for his contribution and question, and reliably informed that and can concur that they were in fact approved in cabinet, that is the regulations, and they will come into force for January 2025. Thank you, Mr. Speaker.
The question is that a bill shortly entitled the Companies Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Companies Amendment and Validation Bill 2024 has been given a second reading.
Companies Management Amendment Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, sorry. Mr. Speaker, I beg to move the second reading of a bill entitled the Companies Management Amendment Bill 2004.
The bill has been duly moved. Does the Honorable Premier and Minister of Financial Services wish to speak thereto?
Yes, Mr. Speaker, and with a correction, not 2004, but 2024. Thank you.
2024.
Mr. Speaker, I rise to present the bill again on behalf of the government. It's a bill that seeks to amend the Company Management Act 2024 revision, being the principal act, to provide that the fee for an application for a license is non-refundable and for incidental and connected purposes. We see as the recurring theme, because of the fact that there's no automatic method in collecting, it's necessary to bring this specific legislation for a number of these financial services transactions, and that because it's been a number of years, some 5, some 10, some 15, that they have not been implemented, the ministry undertook an exercise, and this is one of the byproducts of that exercise. The amendment of the Companies Management Act will form part, as I said, of the legislative package, and it will ensure that the revenues as projected and is deeply relied on in our budget for 2024-2025 will get sufficient revenue to not only meet the needs of the country, but more importantly, the needs of the financial services, as that is our golden egg since early 70s, and hopes it will be for a long time to come. By way of summary, Mr. Speaker, the bill provides that application fee for the grant of a license is non-refundable. The bill is arranged in 2 clauses. Clause 1 provides for the short title and the commencement of the legislation. The ministry, being aware of the impact, as I indicated, took great time to ensure that there was great consultation, and so we are now, the resultant effect is that Clause 2 will seek to amend Section 5(6) of the Companies Management Act 2024 revision to provide that the fee for an application for a license would be non-refundable. And so even though it seems mundane, it will help collective revenue, and I'm asking that all members of this honourable parliament support this, as I conclude by thanking once again all of those involved in the drafting, the research, the collaboration of this. And with that, I commend the Company Management Amendment Bill 2024 to the Honourable House for its second reading.
Thank you, Madam Premier. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, Madam Premier, I'll invite you to close the debate on the bill. I can't say the right of reply because there's nothing to reply to.
Thank you, Mr. Speaker, for your invitation to treat in the closure of this debate on the bill, and I so do. May it please you.
Thank you. The question is that a bill shortly entitled the Companies Management Amendment Bill 2024 be given a second reading. Those in favor, please say aye.
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 Those against, no. The ayes have it. The Companies Management Amendment Bill 2024 has been given a second reading.
Exempted Limited Partnership Amendment and Validation Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled Exempted Limited Partnership Amendment and Validation Bill 2024.
The bill has been duly moved. Does the Honorable Premier wish to speak thereto?
Thank you, Mr. Speaker. Yes, sir. Mr. Speaker, I rise to present the bill again on behalf of the government. It's a bill that seeks to amend the Exempted Limited Partnership Act 2021 revision to provide for applications for name reservations, to provide for the charging of fees for administrative services, to expand the list of transactions in respect which express fees may be paid, to introduce new fees, to validate the Exempted Limited Partnership Regulations 2014, to validate certain revenue collection actions of the registrar, and for incidental and connected purposes. Mr. Speaker, again, it goes without saying that these are necessary. We look forward to the full support as it will bring in additional revenue to the country. It has been some time, and I say that again because it will bring in fees so that persons just don't think it was arbitrarily done. It was done in a collaborated consultative process with consultants there, not only within the ministry, but with the stakeholders as well. And now that the review has been completed, consideration have been taken for whatever impact it would have on the industry. We feel free that we're able to present this Exempted Limited Partnership Act, which will form part of the legislative package so that we can continue and ensure the sustainability of the registrar and CIMA's future activities and the provision thereof, and also the application of the fees. Mr. Speaker, the bill validates the exempted partnership regulations and certain revenue which had been collected by the registrar before the commencement of the legislation, and provides for incidental and connected purposes. It also, as I indicated, will introduce new fees. We'll see that Clause 1, as is customary, provides for the short title and the commencement of the legislation. Clause 2 amends the Principal Act by inserting a proposed Section 5A. The proposed Section 5A, Mr. Speaker, provides for the making of applications to the registrar to reserve a specified name for a company for a period up to 4 months. Clause 3 amends the Principal Act by inserting a Section 12A. This proposed Section 12A, Mr. Speaker, provides for the payment of prescribed fees to the registrar in respect of the prescribed administrative services. Clause 4, Mr. Speaker, amends the Principal Act by repealing and substituting Section 13. The substituted Section 13 provides for additional categories of transactions which may be expedited upon the payment of an express fee, and to increase the express fees in respect of existing transactions. Clause 5, Mr. Speaker, amends Section 36 of the Principal Act. It also introduces a prescribed fee, which is to accompany the filing of a notice for dissolution with the registrar. Clause 6 amends Section 41 of the Principal Act, and it introduces a prescribed fee for the deregistration pursuant to a partnership agreement. Clause 7 amends Section 42 of the Principal Act to provide for the payment of the prescribed administrative fee where a foreign limited partnership ceases to be a general partner of an exempted limited partnership, in addition to the requirement to notify the registrar. Clause 8, Mr. Speaker, amends Section 48 of the Principal Act to provide that regulations made under the Principal Act may also be made in respect to matters relating to foreign limited partnerships. The clause also amends Section 48 of the Principal Act to clarify that regulations made under the Act may prescribe fees payable to the registrar in respect of administrative services under the legislation. Clause 9, Mr. Speaker, provides for the validation of exempted limited partnership regulations 2014 to the extent that the regulations provided for matters relating to the foreign limited partnership without statutory authority. The effect of this clause, Mr. Speaker, is that notwithstanding the aforementioned defect, the fees paid to the registrar in respect of the foreign limited partnerships and any forms for translation certificates submitted in respect to foreign limited partnerships are validated and deemed to have been paid or submitted. Clause 10 deals with the validation of fees collected without statutory authority by the registrar. Where those fees were charged and collected prior to the commencement of this amending and validating legislation, this clause, Mr. Speaker, seeks to validate the collection of those fees by the registrar as if the registrar was empowered to do so under the amending and validating legislation. Clause 11, Mr. Speaker, provides that this amending and validating legislation does not affect any order or determination made by a court relating to fees collected by the registrar without statutory authority for any service provided by the registrar before the commencement of this amending and validating legislation. Mr. Speaker, in concluding, once again I wish to thank the former minister, the minister's staff, the legislative drafting, all members of cabinet, and certain all members for coming to form the quorum so that we could get yet this another important piece of legislation through today. I thank you, Mr. Speaker.
Thank you, Madam Premier. Does any other member wish to speak? The member from Bordentown West.
Thank you, Mr. Speaker. And Mr. Speaker, my contribution is going to be brief, but it pretty much relates to my general view of all of these bills that we're looking at with regards to financial services. And I think it's just worth bringing this to the House and also to the public's attention. Mr. Speaker, when you look at the ESO's report for the spring 2022 survey, labor force survey, you'll see that financial insurance activities employed a total of 4,691 persons, of which 2,882 were Caymanians and 1,808 were non-Caymanians. When you look at that report, Mr. Speaker, and then you also take into consideration the spring 2024 report, you will see that the total amount of people in the labor force increased from 52,764 in 2022 to 61,003 in 2024, which represents an increase of 8,239 persons between spring 2022 and spring 2024. But when you look at the amount of people employed in financial services in 2024, despite the overall labor force being increased by 8,239, the total amount of people employed in financial and insurance activities actually decreased from 4,691 in 2022 to 4,685. Mr. Speaker, I choose to bring that issue up just to highlight one general point. When you look at the importance that financial services play to our overall economy and the large percentage of our GDP that we derive from financial services, it's important for members and the public to recognize, one, the importance of this industry, but two, at the same time, we need to make sure that we recognize that it is still an industry that is not growing. And while we have taken many steps to improve our regulations and also improve the services being offered by financial services, I think we need to move from a position of plain defense, because we have been very defensive in financial services for the longest while, Mr. Speaker. And as you would have, as you and all members are aware of the amount of pressures that come on financial services to bear. But at this point now, we need to start looking at ways in which we can start growing this industry. Because during the same period of time, when you look at the amount of Caymanians employed in that same section, actually decrease compared to the other way around. So it's just something I think that we need to take a stock of in sense of start focusing now in terms of growth. I think we have done a good job in terms of playing defense, but we need to start playing in terms of growth. And when you look at the other competitors out there, I think this is the right time now, when you look at all the different challenges that's going on in China and elsewhere, that we can start getting more business out of Hong Kong and other sides of the world. And while I'm happy to see that the government has opened these foreign offices up or overseas offices, I think we need to start looking in terms of getting the industry together and see what opportunities that we can have to grow this industry. Because, Mr. Speaker, when you take financial services and you look at the amount of people employed, you can basically put those people into two categories. Those that are hunters and those that are farmers. And when you look at inside the industry, there are very few people inside that is employed that are actually the ones who are bringing in the business, developing the business, or basically hunting the business to bring here. A lot of the people that are employed in financial services are generally people who take care of the business after it arrives. But we need to start looking at ways in which we can equip our hunters to go out and actually grow the sector. It is too vital, and we're not seeing the job growth in it as we expected. So I know we have our own challenges, and it is dependent on a lot of overseas factors and a lot of external factors, but I think it's something that every member of this House should be aware of, that this is one industry that is not growing when the rest of the labor force is growing. And when you understand basic economics 101, that you have people who are demand and those who are supply. This is a demand industry. This is the industry that drives the very construction industry and drive other industries, because it is the monies or the people that employs in this industry that basically moves our GDP. So it's just something I think that we need to be conscious of and start seeing how we can actually grow this industry. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? The honourable member from West Bay South.
Thank you, Mr. Speaker. I'll be brief. I'd like to thank the government for bringing the Exempted Limited Partnership Amendment and Validation Bill 2024, probably as a natural extension of the points made by the member for Bordentown West. While we do need to increase the fees due to the last time they faced an increase, I wonder whether or not the Honorable Premier, in her right of reply, could answer. As far as I remember, there were enhancements, commercial enhancements planned for the Exempted Limited Partnership Act. And I don't think the ball rested with the ministry. I think the ball rested with the Financial Services Legislative Committee. So I wonder whether or not that committee has returned to the ministry to finalize their recommendations, because as the member for Bordentown West indicated, while regulation needs to be done, while fees do need to increase over time, it's also good to balance that with commercial enhancements that are appropriate and fit within the framework. As far as I remember, the proposals, the commercial enhancement proposals by the Financial Services Legislative Committee were relatively uncontroversial and would increase the product. And that product of the Exempted Limited Partnership is the primary vehicle for private funds, which of course generate large revenue, and their assets under management are far larger than traditional mutual funds / hedge funds. So if there is going to be a meeting of the House in January, I would imagine that that might be one that we may want to get over the line to polish and enhance this very successful product. And in addition to that, I think the other extension of the member of Bordentown West's point is not necessarily in the numbers, because as the Premier outlined in the unaudited report of the last 9 months, that the numbers are up, but what's more so not happening is the growth of the substance in the country, because a large part of the industry is being outsourced. And there's a variety of factors that relate to that in terms of the treatment in the labor force and the speed in which you can get professionals here in the public sector and the private sector. So that's not something that's going to be answered today, but I just acknowledge the member for Bottom Town West's point, because it is something that in the coming months, either in this administration or more likely in the next administration, will need to be grappled with in order to further support and grow financial services, its substance in the country and the jobs that are in the country. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, then I'll invite the Honorable Premier to exercise her right of reply.
Thank you, Mr. Speaker. Mr. Speaker, I wish to thank the two members who rose to contribute to this important piece of legislation. I wish to, in particular, thank the member from Town West for his keen analytical eye, always looking at the surveys that are coming out from finance, in particular the labor survey, and taking cognizance of the fact, Mr. Speaker, of the number of Caymanians that are involved in industry, and being also desirous, as of all members, I would imagine, within this Honourable House, to see more Caymanians employed as we endeavour to build the middle-income wealth within the nation. I also, Mr. Speaker, can say that with the advent of the overseas offices, which were started under your good self before you demoted officers to a much higher position, the necessity for the establishment of overseas offices was not just aspirational, it was put well into force, and this government, when it came in with the former minister, the member from West Bay South, continued that with the ministry's staff. And so the offices, we believe, will be good conduits that will allow us to be much more proactive, to grow and diversify the industry, so that when the question is asked, who are we developing for, that it would be a collaborative approach. Obviously, we can think outside the box to ensure, as we did with teachers, we can look at the scholarships provision to identify the ones who come from our schools and do extremely well. When I grew up, I came up at a time where the chief officers and those who in personnel would go to the graduations and they would do the hunting, as is done in basketball and baseball, to try to get the brightest of the Caymanians to bring this service. And I want to commend the Honourable Deputy Governor for the efforts that they make within the civil service to almost headhunt those bright Caymanians and try to keep the remuneration and the benefits up to a level that is competitive within the civil service, that we can ensure that we have a good cadre of Caymanians to meet the needs of this very important industry. We're also continuing to work, Mr. Speaker, with Cayman Finance to increase with the promotions that are necessary. And we are currently working actually with Cayman Finance to discuss strategies for growth. And with any other asset, Mr. Speaker, with nation growing, has always been my mantra that all hands on deck is a much better success formula. And I would invite those who have ideologies that not to just save it for campaign manifestos, but we would wish, as the member from West Bay South, to when the House next convenes, whether it's in January or February, to have that ready to bring to Parliament, because we believe it's the next step, a very significant and important component for the continued success of the financial services within a jurisdiction. And then finally, Mr. Speaker, I'm reliably informed that the Financial Services Legislative Committee, that work is continuing, and we will endeavour, bar circumstances beyond our control, to have that ready for when the House next convenes, should that be the guidance of those who make up the quorum of this House. I thank you.
The question is that a bill shortly entitled the Insurance Amendment and Validation Bill 2024 be given a second reading. Oh, I'm moving too far ahead. Forgive me, members. The question is that a bill shortly entitled the Exempted Limited Partnership Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Exempted Limited Partnership Amendment and Validation Bill 2024 has been given a second reading.
Insurance Amendment and Validation Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill duly entitled the Insurance Amendment and Validation Bill 2024.
The bill has been duly moved. Does the Honorable Premier wish to speak thereto?
Thank you, Mr. Speaker. Mr. Speaker, I rise once again to present a bill on behalf of the government which seeks to amend the Insurance Act 2010 revision, being the Principal Act, to provide for the application fee for the application for a license or for registration as a portfolio insurance company is non-refundable, to provide for the payment of annual fees by persons registered under the Act, to amend the provisions relating to the registration of exempted companies as portfolio insurance companies, to validate the charging and indeed the collection of annual fees in respect to the portfolio of insurance companies and for incidental and connected purposes. Again, Mr. Speaker, this is one of the packages of fees that we're bringing that is resultant out of the consultation that was done. And we will see, Mr. Speaker, that the bill is arranged into 8 clauses. Clause 1 provides for the short title and the commencement of the said legislation. Clause 2 amends Section 4 of the Principal Act to provide for the prescribed application fee for a license which is non-refundable. Clause 3, Mr. Speaker, amends Section 7 of the Principal Act to provide for the payment of annual fees by persons registered under the said legislation and in respect to whom a license is not required to carry on insurance business. Clause 4 amends Section 28B of the Principal Act to provide, among other things, that the prescribed application fee for registration as a portfolio insurance company is non-refundable. The clause also amends Section 28B to provide for certain requirements to be satisfied by a portfolio insurance company that wishes to remain registered. Clause 5, Mr. Speaker, amends the Principal Act by inserting a proposed Section 39A. This proposed Section 39A empowers the Cabinet to waive or reduce any or all of the fees pertaining to a license or a registration under the legislation in relation to any person or group of persons in Cayman Brac or Little Cayman. Clause 6 deals with the validation of annual fees charged and collected by and any related surcharges assessed by and paid to SEMA without statutory authority before the commencement of this amended and validating legislation. And Mr. Speaker, out of the abundance of caution, I should say that Clause 6, although agreed and concurred by me, I was not the inventor or the suggester for the special treatment for Cayman Brac and Little Cayman, lest there be headlines to the contrary. Clause 7 provides that this amending and validating legislation does not affect any order or determination made by a court relating to annual fees charged and collected by any related surcharges assessed by or paid to SEMA without statutory authority before the commencement of this amended and validating legislation. Clause 8, Mr. Speaker, provides for the transitional arrangement for applications for a license or a registration for which decisions are pending on the day immediately preceding the commencement of this legislation. The application fee for these applications will also be refundable. Mr. Speaker, it leaves for me just to once again thank the former Deputy Premier Minister of Financial Services, now member for West Bay South, for his work and seeing this package and slew of bills come to the House to raise revenue, as well as the competent chief officer and all of their staff, the legal drafts, members of Cabinet and parliamentary secretaries for agreeing for this, and for those who have come to form quorum today, without which we could not have these bills considered and hopefully duly passed.
Thank you, Madam Premier. Does any member wish to speak? Does any member wish to speak? The Honourable Member for West Bay South.
Thank you, Mr. Speaker. I commend the government and the Premier for bringing the Insurance Amendment and Validation Bill 2024. As one point I wanted to expand on is that this is insurance, and reinsurance is an area of financial services that is in fact growing. It's growing significantly and bringing businesses that do add substance to the country. I'm aware of at least 2, maybe 3 young Caymanians that have recently qualified as actuaries, which is a very technical job, and have landed jobs with new insurance or reinsurance licensees. One of the ideas that we have that hopefully wouldn't need another meeting of the House or need to be inserted in a manifesto because it's pretty straightforward, was to add a category in the insurance framework, which could be brought forward, I think, by regulations, to implement or enact a new class B4. And the reason for that, Mr. Speaker, is because initially as constructed, B3s were the smaller insurance companies and class D are the large reinsurance companies. But we're now starting to see a growing healthy trend of insurance companies that are migrating or establishing in Cayman who are too large to fit within the band as designed for B3, but not necessarily as large to be a class D, which means that if a B4 is implemented, that should have a healthy growth with employment in the country, and then hopefully they will then be able to graduate on to being class Ds, which are the very, very large reinsurers. And that has a complement with our private funds industry. So I just wonder whether or not the Premier, Honorable Premier, in her right of reply, could provide an update as to whether or not the Class B4 proposal will be attempted to be enacted before the end of this administration. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I'll invite the Honourable Premier to exercise her right of reply.
Thank you, Mr. Speaker. Thank members for their tacit support. Thank to the MP from West Bay South for his contribution and for his acts as it relates to B4. I'm reliably informed that it is possible, anything is possible. Obviously, would need the approval and permission from Cabinet to draft the necessary amendments. SEMA has a number of changes that they want to make it more robust. Obviously, elections have been declared for the 30th of April. Chances are we may have one more sitting of this Honourable Parliament. There's Christmas in between, and not only was I without notice thrown in to go and negotiate it in the UK, which I did in the interest of the country, and some 13 bills which I tried to wrap my head and still trying to wrap my head around to present because they are important. So I'm extremely grateful for the full support and collaboration we're having here today. But to stand here today to say that it will actually come, I could not give that commitment because it's a huge portfolio and I received no briefing notes.
The question is that a bill shortly entitled the Insurance Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Insurance Amendment and Validation Bill 2024 has been given a second reading.
Limited Liability Companies Amendment and Validation Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled the Limited Liability Companies Amendment and Validation Bill 2024.
The bill has been duly moved. Does the Honorable Premier and Minister of Financial Services wish to speak thereto?
Yes, thank you, Mr. Speaker. Mr. Speaker, I rise again to present the bill on behalf of the government, the people of the Cayman Islands. It's a bill that seeks to amend the Limited Liability Companies Act 2023 revision, being the principal act, in order to provide a statutory basis for the registrar's collection of fees for several of the general registrar's services. It is also seeking to validate specific previous revenue collections on behalf by the registrar and for incidental and connected purposes. Mr. Speaker, as I move to the summary of the bill, Clause 1 provides a short title and the commencement of the legislation as is customary with drafting. Clause 2 amends Section 46 of the Principal Act. Section 46 empowers the registrar to register a plan of a merger or consolidation between two or more limited liability companies. Clause 2 further amends Section 46 to empower the registrar to charge a fee for the registration of the plan of merger or consolidation. Clause 3, Mr. Speaker, amends Section 50 of the Principal Act. Section 50 empowers the registrar to register a plan of merger or consolidation between one or more limited liability companies and one or more exempted companies. Clause 3 further amends Section 50 to empower the registrar to charge a fee for the registration of the plan or merger or consolidation. Clause 4 amends Section 51 of the Principal Act. Section 51, Mr. Speaker, empowers the registrar to register a plan of merger or consolidation between one or more limited liability companies and one or more foreign entities. Clause 4 further amends Section 51 to empower the registrar to charge a fee for the registration of the plan of the merger or consolidation. Clause 5, Mr. Speaker, amends Section 56 of the Principal Act. Section 56 enables an exempted company to be re-registered as a limited liability company. Clause 5 amends Section 56 to provide also for an application under the section to be termed as an application for re-registration and not a conversion application. Clause 6 inserts into the Principal Act a proposed new Section 59A and Section 59B. The proposed new Section 59A, Mr. Speaker, would empower the registrar to charge a fee for the provision of administrative services. The proposed new Section 59B would set out a statutory basis for the registrar to provide certain express services for a prescribed fee, for example, express services in respect of an application to convert an exempted company into a limited liability company. Section 7 and 8 clauses, Mr. Speaker, deals with the validation of fees that have been collected without the requisite statutory authority by the registrar. Where those fees were charged and collected prior to the commencement of this amending and validating legislation, Clause 7 would now, if passed, validate the fees as if the registrar was empowered under this amending and validating legislation. Clause 8, Mr. Speaker, provides that this amending and validating legislation does not affect a court order, as in the other previous ones, relating to fees collected by the registrar without the statutory authority for any service provided by her before the commencement of this amended and validating legislation. And Mr. Speaker, in conclusion, Again, I wish to thank the former minister, MP for West Bay South, Mr. Chief Officer Dax Bastier and his able staff, the drafting team as well, for the many hours that they spent throughout this past 3.5, almost 4 years drafting all legislation, but in particular the financial regulations and legislation which were very, very necessary for the continued success of the industry and the services. And Mr. Speaker, I therefore commend the Limited Liability Companies Amendment Validation Bill 2024 to the Honourable House for its second reading.
Thank you, Madam Premier. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? The Honourable Member for Georgetown East.
Thank you, Mr. Speaker. Mr. Speaker, I really not really looking to debate the bill, to totally support all of them here today, but looking for maybe a little bit of clarity and further information. But Mr. Speaker, a number of these bills this morning are seeking to implement, validate fees that the collection of fees by related government entity that they have been collecting over a number of years. And I commend the ministry for the exercise that they have undertaken and identified the issue that the legislation that they're responsible for did not include these provisions for the collection of fees. Some of them, particularly I think of something like the company management law, Mr. Speaker, goes back some 60 years. So they've probably been collecting fees for that period of time, which there was no validation. So my question really, I'm not sure if the Premier would know the answer, but perhaps if even if the Attorney General might indicate whether he is aware as well, is given the fact that we also have a bill here, a validation bill, I think, for the ICTA to deal with here today, and I think we did at least one other one last year for another piece of legislation. So it indicates to me that there might be a wider issue throughout government with regard to all of our legislation, whether they all include proper validation clauses. So I'm just curious to know whether there might be some program underway within government to look at all the legislation to make sure that, that we have proper validation clauses in our legislations for the collection of the revenues that which related entities are responsible for. With that, Mr. Speaker, I commend the bill as well and all the others. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I'll invite the Premier, the Honourable Premier, to exercise her right of reply.
Thank you, Mr. Speaker, and thanks again to all members for their implied support and for the members who spoke. I wish to do a short response. I think it was a very important point that the member made. And I just wish to say that I'm reliably informed that the ministry, during its review of the fees, came upon a number of fees that were being collected, but the law did not clearly specify or authorize the collection thereof. So the legislative drafting department is well aware of this, and they're continuing to scope the existing legislation and, of course, future legislation to ensure that it's covered, so that hopefully we'll soon see an end to the validation. But I'm happy that we're not taking a legal point with the validation, because, as the member said, it's gone past several decades, and it would, the nice surplus that we have would have a huge dent to any government, this one or other ones, if we did otherwise. So I'm happy for the support for the validation. Thank you for your indulgence, Mr. Speaker. Just for, out of the abundance of more fulsome reply, the Honourable Attorney General has confirmed what I intimated Suffice to say that it will be done by ministry. Obviously, financial services would be the most prominent one because that's where the work has started, but that the exercise would be from a holistic perspective. Thank you, Mr. Speaker.
The question is that a bill shortly entitled the Limited Liability Companies Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye. Aye. Those against, no. The ayes have it. The Limited Liability Companies Amendment and Validation Bill 2024 has been given a second reading.
Limited Liability Partnership Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you again, Mr. Speaker. Mr. Speaker, I beg to move this second reading of a bill entitled the Limited Liability Partnership Amendment and Validation Bill 2024.
The bill has been duly moved. Does the Honourable Premier and Minister of Financial Services wish to speak thereto?
Yes, thank you, Mr. Speaker. Mr. Speaker, this bill emanates from the same background of the need to bring it up to date to do the various validations that's necessary, as well as to make sure that the fees are relevant. Clause 1 provides for the short title and the commencement of the said legislation. Clause 2 amends Section 37 of the Principal Act, Mr. Speaker, and it enables the Limited Liability Partnership to terminate its registration as a limited liability partnership by filing written notice of termination of the registration with the registrar. Clause 2 further amends Section 37 to empower the registrar to charge a fee for the termination of the registration of a limited liability partnership. And Clause 3 inserts the Principal Act a new Section 45A and 45B. The proposed new Section 45A would empower the registrar to charge a fee for the provision of the administrative services. The new Section 45B would set out statutory basis for the registrar to provide certain express services, also for a prescribed fee. Clause 4 and 5, Mr. Speaker, deals with the validation of fees to be collected without statutory authority by the registrar, and again, Clause 4 would seek to validate the fees as if the registrar was duly empowered under the amending and validating legislation. Clause 5, Mr. Speaker, provides that this amending and validating legislation does not affect a court order relating to fees which have been collected by the registrar without the statutory authority for any service provided by the registrar before the commencement of this amending and validating legislation. And then, Mr. Speaker, in conclusion, once again, I want to thank all those members who probably getting tired to hear thank you, but it's worthwhile saying thank you to member from Georgetown South, Chief Officer Dax Bastien, his staff, legislative drafting, all the members of
West Bay South. West Bay South.
Where I put it?
Georgetown.
Oh, it's getting mighty close. West Bay South. My apologies, please. MP from West Bay South. Wish to thank him. And also all members of Parliament for coming together and agreeing the significance of this important financial slew of bills. So, Mr. Speaker, I therefore commend the Limited Liability Partnership Amendment Validation Bill 2024 to this Honourable House for the second reading, and I thank you for your keen ears.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If the member from Newlands.
Thank you, Mr. Speaker. I thought I would take the opportunity to clarify. I have somebody repeat that I am the member from Newlands. There was a mistaken reference to Savannah earlier. Mr. Speaker, I want to just very briefly say thank you as well to the government, the Premier, for ably bringing these amendments, these really important amendments so far, to this Honourable House. And also recognizing the significant work that was done in relation to this by the member from West Bay South. Mr. Speaker, just very briefly, reference has been made to the significance of the financial services industry. I think anybody in this House or in this country would argue with that. It is clearly a very important element of our economy and contributes massively to our gross domestic product and provides excellent opportunities for Caymanians in this country. I agree that we have to continue to find ways to grow those opportunities. Mr. Speaker, I just wanted to very briefly say, in relation to the several bills that we have seen today in relation to the financial services industry, there are references to express fees being authorized. In my experience in the past, financial services businesses are very happy to pay express fees and very grateful for the opportunity to be able to pay those when they need to move very quickly. I think it's probably worth saying, though, that there have been times in the past when the express fee ends up becoming sort of the de facto fee because there is a significant demand. So just recognizing that we need to be providing excellent services and to avoid a situation where the express fees sort of become the de facto ordinary fees, and there's a perception that our services are becoming more and more expensive. It would be really good if we could try to ensure that those fees do in fact relate to the special delivery of services. And that means really just ensuring that we have the capacity and the capability to continue to provide excellent services to this really important industry. Thank you, Mr. Speaker.
The Honourable Member for West Bay West.
Long, Mr. Speaker, but I've been listening to all members that has risen so far in recognizing the value of the financial services industry. Mind you, when I was minister, and I had all these subjects and was criticized for it, some of those same people said we shouldn't be spending the kind of money that we were spending in putting services overseas, for instance, in Hong Kong, in Dubai, New York, Washington. And now, all of a sudden, it's the best thing since sliced bread. I don't mind that. I do wish sometimes that they would recognize when it was started, and when it was stopped, and when it was restarted again, and when it was stopped again. I still have a good connection with financial services, those people who work there, and I do get the complaints. The one thing, Mr. Speaker, they don't mind so much paying. A lot of them would not like to pay, of course, but they have to. But not so much in paying or how much. It is the bureaucracy that has been built up in this country that is slowing down business in this country. They're even stopping, complaining about hiring. But it's even stopping that. Check with some of the companies, and I hear all the time, well, we talk with the financial services and they're happy. They're not happy. The bureaucracy is killing their business, and we continue to facilitate it. All they up there across the pond got to ask for it. Not even across the pond, way up in the land up there in Europe. All they got to do is ask for it, and we got it. We can't spend money on certain things down here, but we can do all sorts of things for FATF and CTF and this one and the next one, OECD. Fine. We have to behave ourselves internationally. And we have to be seen to be cooperating. But we do not have to give away the house. And I can stop right here. You see this thing called beneficial ownership? We have so much a claim where we got to do it, but nobody else has done it yet. Watch for that.
Does any other member wish to speak? The Honorable Deputy Premier.
Thank you, Mr. Speaker. I just rise to add two things. First off, to thank the Honorable Premier for her ability to take a very complicated circumstance, complicated issue as well, but with her capability as a well-experienced leader and politician and lawyer, there's no queries as to whether or not she could capably do it, but the circumstances of the timing, I think should be highlighted that due to the unfortunate departure of 4 members of the government, that she was thrust into a very difficult situation and had to bob and weave, riding chew gum all at the same time while already dealing with a number of other matters of governing the country. And she's done it with such grace and without even querying. You heard the Honorable Premier say earlier that without even briefing notes. But she don't complain, she's not going to highlight herself, so I thought I would step up and do that. I was going to do it at the end of the bills, but just to add a little recognition that is due, in my humble opinion, to take the number of bills that are before us, and let me just confirm, 14 very complicated financial services bills that the former Deputy Premier brought us, I would say 80% of the way, and the Premier had to take the last stretch of the relay. She must be commended for that. Mr. Speaker, the second point is that I recognize the good member of West Bay West contribution about concerns of beneficial ownership. And over the last 2.5 years, as I watched the former Deputy Premier deal with this very important sector of our economy, I've listened to the remarks in this Honorable House, and by all means I have, not going to pretend like I'm a master in this industry, but I guess a jack of all trades, and my job is to try to understand all elements of our economy. And again, being thrust with dealing with the circumstances of the departure of the 4 members, I myself had to get a proper debriefing of all the great work that the former member was doing, and to get a full assessment as to the beneficial ownerships and the fears and concerns of what people worry about on a regular basis. And I'm happy to say that I better understand the direction upon which limited interest access and what it actually means. I had the pleasure of sitting with the very capable chief officer, of explaining the appropriate maneuvering that we have to do to stay ahead of the global standard, so that we become still attractive, but also navigate the balance of external forces. And I have to say that I am pleased and and think that the appropriate steps that are being taken are ones that are finding a happy medium on the global stage, and that the negotiations by the Honorable Premier, the capable staff within the Ministry of Financial Services, Chief Officer and the AG, and even the previous negotiations by the former Premier is appropriate for where we're trying to keep the standard. And the Premier has done this country justice by making sure that a happy medium is there and ensuring not only us here at home that we will not jeopardize the financial services, but to send a clear message to the international agencies, as well as our motherland, the UK, and the Foreign Office, that we are bold enough to hold and stand our ground in respect to this area, not to be, quote-unquote, guinea pigs that would potentially put us in jeopardy of losing this very strong industry upon which you heard earlier, Mr. Speaker, contributes to over 1/3 of our revenue. So, though I hear the honourable member from West Bay West's concerns, I want to let the country also know that, yes, we have to navigate this very sophisticated and complicated industry called financial services. And yes, there is a lot of people across the world who would want to take our share of what our forefathers have built so well for us to succeed. But I do think that the stakeholders before and now are competent and are guiding and navigating through these turbulent and stormy waters with the appropriate thrusts and winds and fuel to get us through. Will the industry continue to evolve and amend? Yes, and we will continue to respond in kind to make sure that it's in the best interest of our industry. And I want to take this opportunity, which I know the Honourable Premier have said many times, but I am too proud of all the relevant stakeholders from behind the scenes, the legal drafting team, all the members in the Foreign Office, Cayman Office, to facilitate the discussions, the Cabinet Secretary, the AG, obviously, as I said before, the Chief Officer for Financial Services, for their great work. And I do believe that we can feel comforted that we have stated our position, ensured the industry locally that we will not jeopardize the industry in any capacity, and will continue to be the leaders in respect to financial services, and are open to continuing to grow and expand the services that we offer in a global standard way. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, then I invite the Honourable Premier and Minister of Financial Services to exercise her right of reply.
Thank you, Mr. Speaker. Just to thank all honourable members for their contribution, and to also recognize the member, I think I get this right, West Bay West, for his contribution. Successes in a country is built not just by one man, as Rudolph Kipling said, no man is an island, but certainly once you get the foundation right, as Mr. Johnson did, Mr. Bush, yourself, Honourable Speaker, former, make sure I get this right this time, Newlands, when he had financial service, the former DP, and now it's in my lap. It's our awesome responsibility to pick it up whatever stage of the journey it is, and to try our best to improve and not regress. And that's the mantra, God give me help until April, that I will do. After that, from the sidelines, Mr. Speaker.
The question is that a bill shortly entitled the Limited Liability Partnership Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye.
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 Those against, no. The ayes have it. The Limited Liability Partnership Amendment and Validation Bill 2024 has been given a second reading. Honorable members, I believe now would be a convenient time for the luncheon adjournment, and accordingly the House is suspended until 2:30 p.m. Please be seated. Parliament is resumed.
Second readings. Continued. Monetary Authority Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled the Monetary Authority Amendment and Validation Bill 2024.
The bill has been duly moved. Does the Honourable Minister, Premier and Minister of Financial Services wish to speak thereto?
Yes, thank you, Mr. Speaker. Mr. Speaker, this amendment to the Monetary Act again forms part of the legislative package for ensure that measures that have been contemplated and forecasted become a reality for the 2024-25 budget. And, Mr. Speaker, we will note that Clause 1 of the bill provides a short title and the commencement for the legislation. Clause 2 amends the Principal Act by deleting Roman numerals and references to parts and substituting Arabic numerals. Thank you for your indulgence. Clause 3 amends Section 46 of the Principal Act to empower the Cabinet to make regulations in respect of persons registered under any of the regulatory laws. Clause 3 also amends Section 46 of the Principal Act to provide that both regulations which deal with the charging of fees for administrative services and regulations which will remain Schedule 2 are subject to affirmative resolution. Further, Mr. Speaker, the clause amends Section 46 of the Principal Act to provide that certain fees may be prescribed as non-refundable fees. Clause 4 amends the Principal Act by repealing and substituting Schedule 2. Mr. Speaker, the substituted Schedule 2 provides for additional administrative services and their corresponding fees. The substituted Schedule 2 also provides that the specified administrative services are non-refundable. Clause 5 provides for the validation of fees collected by SEMA without statutory authority from a person registered under any of the regulatory laws for any administrative service provided by SEMA prior to the commencement of this amending and validating legislation. Where those fees were charged and collected prior to the commencement of this amending and validating legislation, the clause now seeks, Mr. Speaker, to validate the collection of these said fees by SEMA as if SEMA was empowered to do so under this amending and validating legislation. Mr. Speaker, Clause 6 provides that this amending and validating legislation does not affect any order or determination made by a court relating to fees collected by SEMA without this statutory authority from a person registered under any of the regulatory laws for any of the administrative service that SEMA provided prior to the commencement. Clause 7 provides for the transitional arrangement for the administrative services which are pending on the day immediately preceding the commencement of the said legislation. The fees for those administrative services will be refundable. Mr. Speaker, it leaves for me then to thank the Chief Officer and Minister, Dr. Dax Bassier, and his staff, the Legislative Drafting Department for the efforts with respect to the design and preparation of the bill, the MP from West Bay South for the involvement that he had in getting the bill to almost the finish line, I wish to sincerely thank each and everyone that played a role, including the industry which was consulted. And therefore, Mr. Speaker, I commend the Monetary Authority Amendment Validation Bill 2024 to this Honourable House for its second reading.
Thank you, Madam Premier. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, then I'll invite the Honourable Premier and Minister of Financial Services to conclude the debate on the bill.
Thank you very much, Mr. Speaker. Thank all members once again for their tacit support, and I look forward to the safe passage thereto.
The question is that a bill shortly entitled the Monetary Authority Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. The Monetary Authority Amendment and Validation Bill 2024 has been given a second reading.
Mutual Funds Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. I beg to move the second reading of a bill entitled the Mutual Funds Amendment and Validation Bill 2024.
The bill has been duly moved. Does the Honourable Premier and Minister of Financial Services wish to speak thereto?
Yes, thank you, Mr. Speaker. Once again, I rise to present this bill on behalf of the government. Again, a part of a number of pieces of legislation that we will navigate through Parliament today. The bill provides for charging of fees for certain transactions, Mr. Speaker, to provide that the application fee for a mutual fund license is non-refundable. The bill also validates certain revenue collection actions of SEMA prior to the commencement of this legislation. And Mr. Speaker, the fee structure, as I indicated, was such that there was no automatic realignment, and so it took specific effort through the methodologies of consultation and collaboration to bring us here today. Clause 1 provides a short title and the commencement of the said legislation. Clause 2 amends the Principal Act by deleting Roman numerals in reference to parts, substituting Arabic numerals. Clause 3 amends Section 4 of the Principal Act by introducing proposed subsection 2. The proposed subsection 2 provides that a mutual fund shall pay any fees as may be prescribed for the registration of the mutual fund, including the fees for administrative services provided in the filing of an application form or the filing of an amendment to the application form. Clause 4 amends Section 5 of the Principal Act by providing that an application for a mutual fund license shall be accompanied by the prescribed non-refundable application fee and any fees as may be prescribed for the administrative services provided in respect of the application. Mr. Speaker, Clause 5 amends Section 29 of the Principal Act by introducing a proposed subsection 2A. The proposed subsection 2A, Mr. Speaker, provides that a mutual fund shall submit to SEMA a return in the prescribed form and manner as such intervals as may be prescribed. The proposed subsection also provides that the return shall be accompanied by the prescribed fee. Clause 6 amends the Principal Act by introducing a proposed Section 36A. The proposed Section 36A empowers the Cabinet to waive or reduce any or all of the fees payable under the legislation in relation to any person or group of persons in Cayman Brac or Little Cayman. Clause 7, Mr. Speaker, provides for the validation of fees collected by SEMA without the statutory authority for any administrative services provided by SEMA and for the submission of returns prior to the commencement of this amending and validating legislation. Mr. Speaker, where those fees were charged and collected prior to the commencement of this amending and validating legislation. This clause seeks to validate the collection of those said funds by SEMA, as if SEMA was empowered to do so under this amending and validating legislation. Clause 7, Mr. Speaker, also provides for the validation of any returns that have been made or required to be made prior to the commencement of this amending and validating legislation. And then Clause 8, Mr. Speaker, provides that this amending and validating legislation does not affect any order or determination made by a court relating to fees that have been collected by SEMA without statutory authority for any administrative services provided by SEMA and for the submissions of returns prior to the commencement of this amending and validation legislation. Clause 8 also provides, Mr. Speaker, that this amending and validating legislation does not affect any order of courts, as I indicated, made in relation to returns are required to be made prior to the commencement of this amendment and validating legislation. Clause 9, Mr. Speaker, provides for the transitional arrangement for applications for mutual funds licenses, which decisions are pending on the day immediately preceding the commencement of this legislation. The application fee for those applications will be refundable. Mr. Speaker, this concludes my presentation on a proposed bill, and I thank all honourable members in anticipation for their tacit or audible presentations.
Thank you, Madam Premier. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, then I invite the Honourable Premier and Minister of Financial Services to conclude the debate on the bill.
Thank you, Mr. Speaker. Mr. Speaker, I'm happy to have a very brief conclusion, as there was no audible reply, so I'm very grateful for the tacit support of these very important financial pieces of legislation, which will result in more revenue for the country, so that the financial industry can continue to get stronger and stronger, as well as to be able to provide other necessary service within the domicile jurisdiction. Thank you, Mr. Speaker.
The question is that a bill shortly entitled the Mutual Funds Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye. Aye. Those against, no. I believe the ayes have it. The Mutual Funds Amendment and Validation Bill 2024 has been given a second reading.
Partnership Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled Partnership Amendment and Validation Bill 2024.
The bill has been duly moved. Does the Honourable Premier and Minister of Financial Services wish to speak thereto?
Yes, thank you, Mr. Speaker. Mr. Speaker, again, on behalf of the government, I rise to present this bill. It provides for the name convention for a limited partnership and for the registrar's collection of fees for various services. The bill also seeks to validate certain previous revenue collection actions of the registrar. Further, the bill provides for matters which are incidental and connected to its purposes. Clause 1, Mr. Speaker, again provides for the short title and the commencement of the legislation. Clause 2 amends Section 2 of the Principal Act to include a definition for the words regulatory laws, which have the meaning assigned by Section 2.1 of the Companies Act 2023 revision. Clause 3, Mr. Speaker, amends the Principal Act by inserting the proposed Section 49A, which deals with the name convention for limited partnerships. Among other things, Mr. Speaker, the clause provides that the name of a limited partnership shall end with the words limited partnership or the abbreviation LP, L.P.R, simply LP. Clause 4, Mr. Speaker, amends the Principal Act by inserting a proposed Section 54A, which deals with administrative services. The proposed Section 54A, Mr. Speaker, provides for a prescribed fee. The registrar may provide prescribed administrative services. Clause 5 amends the Principal Act by repealing and substituting Section 55. The proposed Section 55, Mr. Speaker, deals with express fees, expands the list of transactions for which the registrar may charge express fees for an expedited service. Clause 6 amends Section 56 of the Principal Act to provide for, among other things, the making of regulations prescribing the fees payable to the registrar under the legislation, including the fees payable for the provision of administrative services by the registrar. Clause 7, Mr. Speaker, deals with the validation of certain fees collected without the statutory authority by the registrar. Where those fees were charged and indeed collected prior to the commencement of this amending and validating legislation, this clause now seeks, when approved, to validate the collection of those fees by the registrar as if the registrar was empowered to do so under the amending and validating legislation. Clause 8, Mr. Speaker, provides that this amending and validating legislation does not affect, as in the previous bills, in an order or a determination made by a court relating to fees collected by the registrar for a service provided before the commencement of this amending and validating legislation. And so, Mr. Speaker, I wish once again to thank all those who have been involved, including the member from West Bay South, the Chief Officer, Dr. Dax Bastier, his staff, the legislative drafting team, and all members of Parliament who I anticipate, without breaching the rule of anticipation, would give their tacit or audible support. I therefore commend the Partnership Amendment Validation Bill 2024 to this Honourable House for its second reading.
Thank you, Madam Premier. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, then I'll invite the Honourable Premier and Minister of Financial Services to conclude the debate on this bill.
Thank you once again, Mr. Speaker. Indeed, it's my honour and pleasure to thank all members for their continued support for these very important financial bills. Thank you, Mr. Speaker.
The question is that a bill shortly entitled the Partnership Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye. Aye. Those against, no. I believe the ayes have it. The Partnership Amendment and Validation Bill 2024 has been given a second reading.
Private Funds Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled Private Funds Amendment and Validation Bill 2024.
The bill has been duly moved. Does the Honourable Premier and Minister of Financial Services wish to speak thereto?
Yes, thank you, Mr. Speaker. Mr. Speaker, this bill amends the Private Funds Act 2021 revision to provide for the charging of fees for certain transactions and to provide for a non-refundable application fee in respect of an application by a private fund to be registered under the said Act. Clause 1 provides for the short title and for the commencement of the said legislation. Clause 2, Mr. Speaker, amends Section 6 of the Principal Act by introducing a prescribed fee for an application by a private fund to be registered under the Principal Act. Mr. Speaker, Clause 3 amends Section 2 of the Principal Act by introducing a prescribed fee for filing with SEMA details of changes in respect of a private fund. Clause 4 amends Section 14 of the Principal Act by introducing also a prescribed fee for the filing of annual returns by the private funds. Clause 5 provides for the validation of fees collected by SEMA without statutory authority for the registration of private funds the filing of details of changes related to private funds, and a submission of annual reports prior to the commencement of this amended and validating legislation. Where those fees were charged, Mr. Speaker, and collected prior to the commencement of this amended and validating legislation, this clause now seeks to validate the collection of those fees by SEMA as if SEMA was empowered to do so under the amending and validating legislation. Mr. Speaker, Clause 6 provides that this amending and validating legislation does not affect any order or determination made by a court relating to fees collected by SEMA without the necessary statutory authority for the registration of private funds, the filing of the details of changes related to the same private funds, and the submissions of annual reports prior to the commencement of this amending and validating legislation. And Mr. Speaker, Clause 7 provides for the transitional arrangement for applications for registration of the private funds for which decisions are pending on the day immediately preceding the commencement of this said legislation. The fee for those applications will be refundable. Mr. Speaker, in conclusion, once again, I wish to convey my sincere appreciation to all those involved, inclusive of the now customary group, the MP from West Bay South, the Chief Officer, Dr. Dak Bastillo and his staff, legislative drafting, all of the honorable colleagues in Cabinet and this House, parliamentary sectors inclusive, for being cognizant and recognizing and embracing the importance of this legislation. I therefore commend the Private Funds Amendment Bill 2024 to the Honorable House for its second reading.
Thank you, Madam Premier. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, then I'll invite the Honorable Premier to conclude the debate on this bill.
Thank you, Mr. Speaker. Once again, I wish to say a great big thank you to everyone for supporting it. And there's no better support sometimes than tacit support. And so I quite welcome that. And with that, I once again commend the bill and look forward to its safe navigation through this honorable Parliament.
The question is that a bill shortly entitled the Private Funds Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. The Private Funds Amendment and Validation Bill 2024 has been given a second reading.
Securities Investment Business Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled Securities Investment Business Amendment and Validation Bill 2024.
The bill has been duly moved. Does the Honourable Premier and Minister of Financial Services wish to speak thereto?
Yes, thank you, Mr. Speaker. Mr. Speaker, this bill seeks to provide a validation of fees collected by SEMA prior to the commencement of this legislation. It also seeks to provide definitions for words used in the legislation. And indeed, we see again that Clause 1 provides a short title and the commencement of the legislation. Mr. Speaker, Clause 2 amends Section 2 of the Principal Act, among other things, by inserting definitions in the legislation. And Clause 3 amends Section 5 of the Principal Act to provide for fees for deregistration and notification of material changes by registered persons. And then Clause 4 amends Section 6 of the Principal Act to require an applicant for a license to specify the category or categories for which an application is being made. The clause also inserts new provisions that provide for A, the prescribing of different fees for different types or categories of licenses, and B, the procedure by which the holder of a restricted license may have certain restrictions on the holder's license adjusted. Mr. Speaker, Clause 5 amends Section 2 of the Principal Act to clarify the power that the Cabinet, after consultation with SEMA, may exercise to prescribe any fees payable under this legislation. Clause 6, Mr. Speaker, amends Section 16 of the Principal Act to empower SEMA to exempt certain persons from registration or licensing under the legislation. Clause 7 provides for the validation of the payment of fees to and the collection of fees by SEMA for the deregistering of securities investment business, the filing of material changes by registered persons under Section 5, and the grant of a registered license prior to the commencement of this amending and validating legislation. Mr. Speaker, Clause 8 provides that this amending and validating legislation does not affect any order or determination made by a court relating to the fees which would have been collected by SEMA without the necessary statutory authority for the deregistering of a securities investment, the filing of material changes by registered persons under Section 5, and a grant of a restricted license prior to the commencement of this amending and validating legislation. And once again, Mr. Speaker, I wish to thank all of the necessary persons, the MP from West Bay South, Dr. Dax Basio, the Chief Officer for Financial Services, the Legislative Drafting Department, and all members present here today for their anticipated contribution, be it tacit or otherwise. And I therefore commend, Mr. Speaker, the Securities Investment Business Amendment and Validating Bill 2024 to the Honourable Parliament for its second reading.
Thank you, Madam Premier. Does any other member wish to speak? The Honourable Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, I would like to rise to briefly speak on a series of financial services amendments and validation bills that have come before us today. Mr. Speaker, I can confirm that the official opposition had agreed with the Honourable Premier to provide a quorum and support these amendments. Mr. Speaker, I would like to take this opportunity to congratulate the Honourable Premier for successfully bringing these crucial pieces of legislation to this esteemed House, as they are, Mr. Speaker, vital for maintaining the fiduciary integrity of the government's budget. Mr. Speaker, I understand that this has not been an easy task. Given the Premier's current position with a minority government and the additional workload following the resignation of 3 of her ministers. Mr. Speaker, it has been a long time since any fees in this sector had been increased, and the industry has evolved, and new fees needed to be introduced. And whilst I will not delve into the specifics of these increases, as Mr. Speaker, the Premier articulated them very well in her presentations, it is my hope that the industry will be prudent in how it seeks to recoup these fees. Mr. Speaker, financial services are an important part of our economy, which appears to be thriving. But nonetheless, Mr. Speaker, I echo the sentiments of those who caution against jeopardizing the very source of our prosperity. As a jurisdiction, Mr. Speaker, we must not become complacent. We must recognize that the cost of doing business and the cost of operating has risen over the past few years. And, Mr. Speaker, other jurisdictions are actively offering incentives to attract our business. Mr. Speaker, we should be reminded the lesson learned from our belief that cruise ships would never stop coming to the Cayman Islands, despite our assumptions of being the best jurisdiction to visit. We are witnessing a shift, and the numbers are declining at an alarming rate. So, Mr. Speaker, let us not become complacent, because if we do, the impact will be immediate, and the ability to recover would be a very long and difficult road. So, Mr. Speaker, with those few words, I'd like to close. But I would also like, Mr. Speaker, to commend all members of this august House for demonstrating today that the Cayman Islands is a mature democracy, that despite our political differences and the recent interruptions, the welfare of our country and its people remain at our paramount concerns. Mr. Speaker, with those few words, again, I'd like to say that the official opposition support these amendments as they have been laid out by the Premier, and I'd like to congratulate herself and all those involved in getting us to this point with them. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, then I'll invite the Honorable Premier to exercise her right of reply.
Thank you, Mr. Speaker. Thanks to the Honorable Leader of the Official Opposition for his remarks and for his continued support from day one that we found ourselves in this situation. And I want to say that history will be kind to him for the mature position that he took with agreeing to form quorum straight up from day one. And so, Mr. Speaker, once again, I am wishing to thank the member MP from West Bay South, the Chief Officer, Dr. Dax Bastillo, the Legislative Drafting Committee, and all members in this House who see the importance of this and have agreed through either expressly saying so privately or on the floor or by their tacit support. So I therefore commend this bill for the second reading, Mr. Speaker.
The question is that a bill shortly entitled the Securities Investment Business Amendment and Validation Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. The Securities Investment Business Amendment and Validation Bill 2024 has been given a second reading.
Virtual Asset Service Providers Amendment Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you again, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled the Virtual Asset Service Providers Amendment Bill 2024.
The bill has been duly moved. Does the Honorable Premier and Minister of Financial Services wish to speak thereto?
Yes, thank you, Mr. Speaker. Mr. Speaker, I rise to present the bill on behalf of the government. It's a bill that seeks to amend the Virtual Asset Service Providers Act 2024, revision being the principal act, to amend definitions and to provide new definitions of terms used in the act, to improve the supervision of certain virtual assets activities, to provide that the fees payable under the act are non-refundable, and for incidental and connected purposes. Mr. Speaker, the Virtual Asset Service Providers Act that was passed on the 25th of May 2020 in consultation with the Cayman Islands Monetary Authority, SEMA, a decision was taken to commence the act in two phases to allow for the gradual implementation of the requirements contained therein. The first phase, Mr. Speaker, of the framework commenced specific provisions on the Act on the 31st of October 2020, which related to the AML and CFT supervision of virtual asset providers, VASPS. This phase was necessary, Mr. Speaker, for the re-evaluation of the Cayman Islands by the Caribbean Financial Action Task Force on Recommendation 15, that is the implementation of the anti-money laundering and countering of the financing of terrorism global standards for new technologies. It also, Mr. Speaker, has allowed SEMA and the Ministry to collect valuable information under VASPS currently operating in the jurisdiction and the types of activities that they are engaged in. Mr. Speaker, a number of possible amendments to the Act have been identified since its passing in 2020. These were identified by the Ministry or by internal stakeholders and include changes which pertain to the scope of the legislation and to the operational elements of the regulatory framework. Changes include, Mr. Speaker, A, clarifying the scope of the legislation and certain definitions, B, introducing definitions for Phase 2 elements of the said legislation, and C, allowing for persons already registered under another regulatory law to provide notice instead of applying for dual registrations. D, improving the supervision of certain specific virtual assets activities. E, make operational changes to requirements for the provision of virtual asset services. And F, to clarify enforcement provisions of the Act, including powers of SEMA. And G, revise certain elements of the legislation based on the feedback that was received. Phase 2, Mr. Speaker, of the framework consists of the licensing of trading platforms and virtual assets custodians to increase the supervision of those activities. Since the licensing of those activities has not yet commenced, there are a number of entities currently registered with SEMA under the Principal Act, which should be licensed. The licensing regimes will ensure that this is corrected. Mr. Speaker, commencing the licensing regime is therefore a critical, important aspect to the proper supervision of the virtual asset services within these Cayman Islands. The bill prepares the Principal Act for commencement of licensing regimes for trading platforms and virtual assets custodians. Mr. Speaker, the bill has undergone extensive consultation with internal and external stakeholders. Previous versions of the bill were sent for consultation with heads of industry associations and their members on 2 occasions in September 2022 and February this year. Revisions being made to the bill based on the feedback that was received. Mr. Speaker, the bill amends, as I said, definitions and does in fact provide new definitions of terms to be used in the legislation. It provides for the improved supervision of certain virtual assets activities. Mr. Speaker, Clause 1 provides for the short title and the commencement of the said legislation, and Clause 2 provides for the deletion of certain definitions and the insertion of new definitions. The new definitions, Mr. Speaker, inserted include convertible virtual asset, financial services business, and originator. Clause 3 amends Section 3 of the Principal Act to change the reference to existing licensee to a supervised person. This amendment, Mr. Speaker, is consistent throughout the amended legislation and reflects the change reference to persons who are licensed or registered by SEMA under any of the other regulatory laws but are not licensed or registered under the Principal Act. Clause 4, Mr. Speaker, amends Section 4 of the Principal Act to provide that, among other things, a person who is not registered, licensed, or granted a waiver shall not state, imply, or convey that the person is regulated or authorized by SEMA to provide virtual asset service. Clause 5, Mr. Speaker, of the Principal Act, Section 5, adjusts the application procedure and point at which fees are payable by the applicants for a registration or for a license. The amendment also, Mr. Speaker, empowers SEMA to publish in the Gazette a notice of lapse of license or registration where the renewal fee remains unpaid for 3 full months after becoming due on the 15th of January in any given year. The amendment to Section 5, Mr. Speaker, also provides that the prescribed fees under the legislation are non-refundable. Clause 6 amends Section 6 of the Principal Act to empower SEMA to impose conditions on an applicant for registration based on the nature, the risk, and the scale of the business. The clause also amends Section 6 of the Principal Act to provide that the shareholders, the directors, the senior officers of an application for registration shall be fit and proper persons. If a registered person wishes to engage in activities for which a license is required under the Act, Clause 6 provides that SEMA shall require the registered person to apply for a license and cancel the registration if a license is granted. Clause 7, Mr. Speaker, amends Section 8, which also empowers SEMA to impose conditions on an applicant for a license at the time of the application or at any time after, having regard to the nature, the risk, and the scale of the business. The clause also amends Section 8 to provide that SEMA shall grant the license on the payment of the license fee, and the license shall state the specific service that the licensee is permitted to carry on. Clause 8 amends Section 9 to provide that as a part of the general requirements for virtual asset service providers, SEMA may require a registered person to provide audited statements where it determines that they are required to do so due to their nature, their size, or complexity of the registered persons, or where the registered person may have provided false or misleading accounts. The clause also provides for an amendment to Section 9, Mr. Speaker, to provide that the virtual assets provider is required to ensure the accuracy of not only the communications, but all disclosures, advertising materials relating to the virtual asset service as well. The clause provides that where a virtual asset provider wishes to make a change to the approved business plan that modifies the provision of the virtual asset service for which a license or registration has been granted, the virtual asset service provider must seek the written approval of SEMA. Clause 9, Mr. Speaker, amends Section 10 to expand on the disclosure to clients that SEMA may require a licensee to provide. Mr. Speaker, these include disclosures to clients regarding regulatory obligations, grievance procedures, the sharing of clients' information to third parties, and internal custodial governance arrangements. The clause also amends Section 10 to provide SEMA that they have the power to impose requirements on a licensee regarding the manner in which the virtual assets are held and maintained on behalf of the clients, and the provision of products and services which derive their value from underlying virtual assets. Mr. Speaker, Clause 9 further provides, among other things, for the amendment of Section 10 to require that a virtual asset service licensee that is providing virtual asset custody services shall take steps as may be necessary to safeguard virtual assets held on behalf of third parties, maintain accurate records that are readily established the precise nature, amount, location, and ownership of clients' assets, and segregate clients' assets from proprietary assets and assets of any affiliate. Clause 10, Mr. Speaker, provides for the repeal of Section 13. Clause 11 provides for the repeal and substitution of Sections 14 and 15. The new Section 14 empowers SEMA to direct a virtual asset service provider to apply for a license of registration under any of the other regulatory laws where A, it is carrying on financial services business that is materially similar to the financial services businesses for which a license or a registered regime under any of the other regulatory laws provides sufficient oversight and supervision for that business, or, Mr. Speaker, B, it requires additional oversight that is provided for in the licensing or registration regime under another regulatory law. The new Section 15 provides for the procedure for an application for a license, registration, or waiver for a supervised person who wishes to carry on virtual asset services. Mr. Speaker, an application is not required where the supervised person is carrying on virtual asset activities involving virtual service tokens only. Clause 12, Mr. Speaker, provides for the amendment of Section 16. The provision empowers SEMA to revoke a waiver granted where it is of the opinion that, amongst other things, there is a change in the size, the scope, the risk of complexity of the business operations, and registration of a license is now required. Clause 13, Mr. Speaker, provides for the amendment of Section 19 to delete and substitute references to existing licensee, sandbox application fee, and application fee, among others. The clause also amends Section 19 to provide that SEMA, in reviewing an application for a sandbox license, shall consider the fintech service and its probable effects on financial services business. Clause 14, Mr. Speaker, provides for the repeal of Part 4, which dealt with decisions to license, register, and approve issuances of virtual assets. Clause 15 provides for the amendment of Section 24 to empower SEMA to request information from any person who is carrying on virtual asset service in contravention of the Principal Act, and to have access to any books, documents, virtual assets, or securities as SEMA may reasonably require for the performance of its functions under the Act. SEMA is empowered to authorize a person with the requisite technical experience to examine the affairs or business of a licensed, registered person or other person carrying on virtual asset services. Clause 16, Mr. Speaker, provides for the amendment of Section 25 to provide that SEMA may, at the expense of the virtual asset service provider, appoint a person to advise the virtual asset service provider on the proper conduct of its affairs and to report back to SEMA on its appointment. SEMA, pursuant to the said report, may revoke the license, cancel the registration, and apply to the court for an order that the virtual asset service provider be wound up by the court. Mr. Speaker, Clause 17 amends Section 26 to provide that where SEMA is of the opinion that a virtual asset service provider is falsely stating, implying, or conveying to the public that it is licensed in accordance with the Act, SEMA may direct that a virtual asset provider cease carrying out the acts and instead take such steps that are necessary in the opinion of SEMA to remedy the conduct. Clause 18, Mr. Speaker, amends Section 27. This is to repeal and substitute subsection 1. The new subsection 1, Mr. Speaker, provides that SEMA may revoke a license or a waiver or may cancel a registration or approval for a virtual asset issuance where it is of the opinion that the virtual asset service provider, A, has failed to comply with an obligation imposed by the Principal Act, B, is carrying on business in a manner that is not permitted by the license or the conditions of the registration or waiver, C, has provided SEMA with false, misleading, or inaccurate information, D, the interests of clients or potential clients for the virtual asset service provider are threatened, or E, the virtual asset service provider has contravened the Anti-Money Laundering Regulations 2023 revision. Clause 19, Mr. Speaker, amends Section 28 to delete and substitute the words a legal person with the words a company or partnership, and the words the legal person or legal arrangement with the company or partnership. Mr. Speaker, Clause 20 amends Clause 30, Section 30, to provide for an appeal to the court for the refusal by SEMA to grant a waiver for a supervised person to engage in the virtual asset service. Mr. Speaker, Clause 21 amends Section 31 to provide that every licensee or registered person which has been directed to provide audited financial statements shall have its accounts audited by an auditor who is a chartered accountant, a certified public accountant, or other professionally qualified accountant approved by SEMA. Clause 22 amends Section 32 to require that if an auditor in the course of carrying out an audit or producing a report under Section 9 becomes aware of or has reasonable grounds to believe that a licensee or registered person is carrying on or attempted to carry on business in a fraudulent or criminal way, to immediately give SEMA, the licensee, the registered person, written notice of this belief. The clause also provides that a person who contravenes subsection 1 that sets out the requirement that an auditor notify SEMA commits an offense and is liable to a fine of $20,000. Mr. Speaker, Clause 23 provides to repeal the substitution of Section 33. The clause sets out the provisions for the entry and search of premises where a magistrate is satisfied by information on oath that there are reasonable grounds for believing that an offense has been committed or is being committed, and that the evidence of the commission of the offense is to be found at any premises or in an electronic device. The clause provides that the magistrate may authorize entry to the premises in which the electronic device is located by persons as may be specified. Clause 24, Mr. Speaker, amends Section 39 to delete and substitute the words financial service business with the words financial services business. Mr. Speaker, Clause 25 provides for a general provisions for amendments for the Principal Act to delete and substitute certain cross-headings in the Principal Act. It also provides for the deletion and substitution of the words application fee for the words licensing or registration fee and assessment fee with the words application fee. Mr. Speaker, Clause 26 provides for the transitional arrangements for the applications for which a decision is pending on the day immediately preceding the commencement of this amending act. The application fee for those applications will be refundable. Mr. Speaker, in conclusion to my presentation on the proposed bills, I wish to thank again the MP from West Bay South, Chief Officer Dr. Dax Pasteur, his staff, the Legislative Drafting Department, all members of Parliament for their express or tacit support and any contribution they had with the design and preparation of the said draft bill. I therefore commend, Mr. Speaker, the Virtual Asset Service Providers Amendment Bill 2024 to this Honourable House for its second reading. I thank you.
Thank you, Madam Premier. Does any other member wish to speak? Does any other member wish to speak? The Honourable Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, rise on behalf of the official opposition to give our support to the Virtual Assets Service Providers Amendment Bill. I think, as the Premier said earlier, this was a sector within the emerging industries that we focused on during our second term in office. And I'm happy to see that the legislation is evolving as the times do with virtual assets. It's important that we continue to be the leaders in regulatory framework, whether it be in the traditional financial services or in areas such as virtual assets, Mr. Speaker. I also believe, Mr. Speaker, that virtual assets is here to stay, it's not going away, and that it's an excellent opportunity for us to explore virtual assets as part of effort to diversify our economy and not only rely on the revenue streams of traditional financial services and tourism. As I said earlier, Mr. Speaker, this sector is growing rapidly, and if the Cayman Islands can position ourselves as a hub for virtual assets, this will create the environment and opportunities for our own Caymanians to have startups or to evolve their established businesses into that virtual asset sector. Mr. Speaker, the other benefit of virtual assets or investing in virtual assets and creating the legislative framework for virtual assets demonstrates to the world that the Cayman Islands is known not only for its robust regulatory framework, but that we are leading the charge on technology in areas such as cryptocurrencies and block and chain technology. So with those few words, Mr. Speaker, we in the official opposition support these amendments.
Does any other member wish to speak? Does any other? The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I rise to lend my voice in support of the bill as piloted by the Honorable Premier. And I perhaps would like to begin where the Honorable Leader of the Opposition has left off, which is that by doing what we're doing here, we demonstrate into the world that, among other things, we are a leader in regulatory framework for these sort of activities. Mr. Speaker, this is important because regionally, Cayman Islands has been recognized as one of the countries with significant footprint in the business of crypto and virtual assets. In fact, Bahamas and the Cayman Islands are basically the front runners regionally in the business. The other countries, leading countries, are also involved, Mr. Speaker. And it was no surprise that we were out front, we mean in the Cayman Islands, was out front very early in seeking to regulate the business. We enacted legislation 2020, and in 2022 we implemented what is known as the travel rule, Mr. Speaker, which was, we were one of the first countries to do so in regulating implementing the travel rule. And what that is, Mr. Speaker, is simply persons who are involved in the virtual asset business, in order to prevent or mitigate, for that matter, money laundering or terrorist financing activities by those who deal in the business. The anti-money laundering regulations were amended to require the persons involved to obtain, hold, and transfer certain transactional data. When they're doing wire transfer, for example, information relating to the originator or the sender and the beneficiary of those transactions. So those data, that sort of data is required to be retained, obtained, retained, and transferred. Mr. Speaker, because the data is transferred real time when the transaction is taking place. or put another way, because the data travels at the same time when the transaction is taking place. It is called the travel rule. So the data travel with the transaction. And we're one of the first countries to implement that. Other countries have followed suit since then, the UK, Canada, United States, and others. But we, certainly at the FATF level, have been recognized. We, meaning the Cayman Islands, have been recognized for a proactive step in that direction. And you will see, Mr. Speaker, that in the bill here, clause 18 speaks to the fact that one of the reasons why, one of the bases on which a license may be revoked, Mr. Speaker, is where there is a contravention of the anti-money laundering regulations. And that points especially or specifically, to the issue of the expectation that service providers, VASP, virtual asset service providers, will ensure compliance with the anti-money laundering regulations as it relates certainly to the travel rule. And so Mr. Speaker, the amendment to the framework here is quite timely, it's quite important. It coincides with the FATF's ongoing work, Mr. Speaker, in revising recommendation 16 of the FATF 40 recommendations dealing with virtual assets and the travel rule. So our enhancement of the regulatory framework here and the licensing framework is quite timely, Mr. Speaker. And so I'm fully in support of the enhancement to the licensing regime. It certainly augurs well for us and for our reputation. Mr. Speaker, I heard this morning some observation about some of what we're trying to do and whether it is good for business, if I might put it that way, my words. Certainly a word of caution about some of the regulatory things that we're pursuing. Mr. Speaker, I would just like to say that Cayman Islands has an excellent track record when it comes on to regulating our financial services industry. And I wasn't here then, but I'm aware that when the Cayman Islands signed the exchange of notes for narcotics in the 80s, there were those who thought that was the end of the financial services industry. And then we entered into mutual legal assistance with America, and it was also said that was the death knell for the financial services industry. We signed the European Union Savings Directive, and there were those like Tax Justice Network and other network who danced on top of the table because they thought that was it. Cayman Islands financial services industry is finished. We signed the Tax Information Exchange Agreement, Mr. Speaker, and we're still, the industry is not just surviving, it is thriving. The financial services industry is thriving. And so I would just say that fear not. There is good sense to what is being done in terms of the regulatory framework that we put in place. Those who are involved in legitimate business would want to know that they're investing in a country that abide by the rule of law and things are done legitimately. And I think, Mr. Speaker, our track record over the years have certainly demonstrated that. We have been recognized certainly by the standard setters, the FATF, OECD, and others. It is no coincidence that we have been invited to be one of only 2 guest jurisdictions as a member of the FATF, Mr. Speaker. That augurs very well for our reputation to use the FATF president's word. They see the Cayman Islands as a lighthouse, certainly in the region, when it comes on to being standard bearers and so. So, Mr. Speaker, I certainly would like to commend the bill to honorable members of this House I think the country, in terms of its regulatory framework, is always on the right trajectory, and we are not afraid to go out in front and lead the way and set the standard, Mr. Speaker. And so this is yet just another example of us seeking to do so, rightly so, I might add. Thank you. And so I commend the bill, like the Honourable Premier, I commend the bill to honourable members of this House.
Does any other member wish to speak? Does any other member wish to speak? Does any other, the Honourable Member for West Bay South?
Thank you, Mr. Speaker. I rise to support the Virtual Asset Service Providers Amendment Bill 2024. As this is the last of the 13 financial services bills, mainly to generate revenue, I'll take an opportunity, Mr. Speaker, to give sincere thanks to the ministry team, the agencies, and the statutory authorities. We could not have accomplished all of the work that was done, not just for these 13 bills, but also as articulated by the Honorable Premier in the report of the ministry for 2023, if we did not work in collaboration, close collaboration, in an organized fashion. It is a complex area. Financial services has grown tremendously over the decades. It involves, as Mr. Speaker knows all too well, heavy travel. And we did our best to ensure that even when there was a temporary absence due to travel, that the main points of any particular matter were summarized so that someone standing in my shoes could pick up the broad strokes and ably deal with it in a short time period. It was a pleasure working in that fashion, which has been displayed here today by the Honorable Premier, who's been able to adequately address questions of members, and I can see that is in no small part to the briefings received by the ministry, who gave the same to me when I first took office. So we have, as the leader of the opposition has said, mature democracy and advanced democracy that can weather storms. It isn't easy to be trapped and caught between your conscience, public overall duty, versus the duties that you have of cabinet. The situation was extreme, as the current Deputy Premier said in a prior bill debate. But I'm very grateful and can't thank the ministry team enough. This bill, though, Mr. Speaker, is slightly different than the other 12, in that it's not just generating financial services revenue. It is also expanding the area of virtual assets, which is even more complicated and new and emerging. But I was comforted, as I was with the other 12, but in particular with this one, that due to the extensive consultation with industry throughout on all matters, including beneficial ownership, that there would be very little resistance or turbulence that anyone standing in my shoes would face, given that industry was brought up to speed, as referenced many times by the Honorable Premier. But I also want to, Mr. Speaker, specifically on this legislation, in view of the Premier's offer to not wait for ideas on the campaign trail or a future meeting, is that as I looked over and read the bill and then reread it during the lunch break, there's still more that we could do here today, this evening, for reasons, as we've said, to try to grow the industry in many, many aspects. There's one item that I know the ministry is familiar, as well as the Monetary Authority, of being able to exclude what is known as blockchain or token funds from the virtual assets legislation, specifically for the definition of issuance of virtual assets. That is because, Mr. Speaker, those token/blockchain funds are essentially the investment funds that we regulate right now under the Mutual Funds Act and the Private Funds Act. But they're moving from being an electronic, centralized spreadsheet of the data to the data being captured in the new blockchain technology. And from my recollection of all of our trips and study of the FATF does not intend to have a financial asset caught at the same time as a virtual asset. And our investment funds product is very much a financial asset. And this isn't pie in the sky, Mr. Speaker. Some of the largest asset managers in the world that do business with Cayman right now, BlackRock, KKR, Apollo Management, huge private equity houses who have funds registered with SEMA right now, are beginning to shift to this new technology. They see it as the way forward. They see it as the way of the future. It creates 24-hour service, better capturing of data, better security features. And soon, this will begin to overtake the traditional model that's happening now of electronic spreadsheets. And we do not want our bread and butter business, the investment funds industry, to be left behind. We are losing at present market share to competitor jurisdictions who have shifted their legislation to accommodate token investment funds, blockchain investment funds versus the traditional registers. Mr. Speaker, we have an opportunity to still work in collaboration, use each other's knowledge no matter what side of the aisle that we're on, to try to generate revenue, because financial services industry knows the consultation on these 13 bills weren't easy. They knew, largely speaking, that the revenue being raised would not be reinvested, lion's share of it, back into financial services. So these weren't easy consultations. They're doing what they believe is their national duty. But at the same time, they need to also be presented with opportunities to continue to grow the industry. So I took the opportunity, Mr. Speaker, to file a committee stage amendment at lunchtime that I hope will be favorably viewed when we get to committee stage. At the moment, I understand that SEMA is taking these token and blockchain investment funds on a case-by-case basis. But what they really need is a legislative amendment that allows it specifically and allows them at the same time to issue a guidance note or a rule so that they can mitigate against any unintended consequences, because these are not, again, just to reiterate, crypto coins. These are blockchain, these are investment funds utilizing blockchain technology. Because as the leader of the opposition quite rightly said, there's a shift, and we cannot be complacent. We have to work in the spirit of cooperation. So with that, Mr. Speaker, I would look forward to favorable consideration during committee stage amendment to really help and grow this area, really be able to maximize the full potential that is within our bread and butter business, not extending beyond something that is radical, untested. These are funds that are already regulated under the Mutual Funds Act, already regulated under the Private Funds Act, just the same passengers but a more modern vehicle. So thank you, Mr. Speaker. I thank the government for continuing the work, and I continue to work, all of us in this House, work as diligently as we can, in cooperation as we can, to continue to grow the country's key financial pillar. Thank you, Mr. Speaker.
Honorable member for West Bay South, I would just advise you that I have not yet seen your proposed committee stage amendment, which will need the Speaker's approval because the relevant notice period hasn't expired. So we can ensure that that reaches me before we go into committee stage, which is going to be shortly.
Mr. Speaker, I'm aware, and I took it upon myself to file it during the lunchtime when I spotted the observation. It should be with you shortly.
Thank you. Is there any other member wish to speak? The Honorable Deputy Premier.
Thank you, Mr. Speaker. I wasn't intending on speaking, as I was hoping for a transition of these bills without any touch of politics. Because of the sensitivities of the financial services and the importance of it to our community. Unfortunately, I saw that the former Deputy Premier ever so delicately and gently scoped around the notion of suggesting that he left everything in place in the event of a mature democracy, that things can go ever so smoothly. And Mr. Speaker, you would have heard me speak earlier in respect to acknowledging the hard work of the Honorable Premier to embrace a rather difficult circumstance and maneuver and think on our feet to get through a very complicated area without notice. And Mr. Speaker, you would also have heard the Honorable Premier say that without any briefing notes available for her or left by the former minister, we were forced into a circumstances of thinking on our feet and many sleepless nights. To be honest with you, I haven't even seen her for a full 6 hours since then, besides caucus, because she has had to put her full attention to this ever so important set of bills, because it not only has to do with our main industry, but also to do with the revenue necessary.
Honorable Deputy Premier, I'm sure you're soon going to reach the point of debating the bill.
Yes, sir. The bill point is that the honorable member, and I think it's fair to say it's in the scope of the discussion, and I hope that there's no conflict in what I'm saying here from you, Honorable Mr. Speaker, as you in charge of this Parliament, but the scope of it is there is a discrepancy by the Honorable Deputy Premier as to say he left everything well and good over here, when in fact that is not true. Mr. Speaker, the simple...
Just a moment. Honorable members, let's please not get into a dogfight over this, right? I think the point has been made. Honorable Deputy Premier, you've made it 4 or 5 times. So can we just get to the debate on the bill in question? As you said, this is important matter. This is the House of Politics, I know that. But really, you've made the point repeatedly.
As you said, Mr. Speaker, I'll just make this last point, then I'll sit down. That as far as I'm aware, Mr. Speaker, we almost didn't have the opportunity to bring these bills to the House at all, because if we had an early election, we would have been in the jeopardy of these very important bills not being there. So the suggestion by the member to suggest that he left this great transition is, I find troubling. And though we have made the best of the circumstances, let the public be fully aware that the Honourable Premier and those who stuck around to make sure the country kept stable, because we could have been at some serious risk in our financial services by the vacation of that member. That's the point I'm trying to make. And for him to allow this perception of anything other than that would be simply dishonest. Thank you, Mr. Speaker.
Honourable Member for West Bay South.
Point of order, Mr. Speaker. I was not in any way believe dishonest whatsoever, and I never imputing improper motives. And I never said that I left a perfect house. I only thanked the ministry, but I could clearly see, based on the responses given to the Premier, that they were briefing the Honourable Premier. That's the only point I made, was to thank the civil service. I did not make the suggestion that the Deputy Premier has said.
Very well. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, I'll invite the Honourable Premier to exercise her right of reply.
Thank you, Mr. Speaker, and thanks to all honourable members who deemed it important to come to make the quorum, as well as to give their tacit support, as well as to get on their feet to contribute in their own way. Certainly, I think it goes without saying that the commonality in the debate throughout the course of the day is that persons recognize the importance of these pieces of legislation. And for me, it matters not who get the kudos. What matters is that the provisions are passed through this Parliament today with the support of all members. We have set the date for election. There'll be many, many occasions for persons to say what happened from what didn't happen, and jury will be out on the 30th of April, when the people will show its maturity by exercising the right, certainly for us women, that we had to fight for back in 1959. And I would encourage them to go out, register, get vote, and continue to put the good ship Cayman in the right direction. I believe that today exemplifies what can be accomplished when hearts and minds come together and egos are left at the door, on both sides of the House for that matter, and that we can do the business that the people elected us to do, Mr. Speaker. So it has not been an easy ride, but as I've said many, many times, heights by great men reached and kept were not attained by sudden flight, but while their companions slept, were toiling upward in the night. We were elected to do what's best for this country, and that is my modus operandi. I may not be perfectionist, may not be the most popular, but one thing people can say, that I try at all material times to do what is in the best interest of this country. Long may it continue for all members in this House. I thank you.
Thank you, Madam Premier. The question is that a bill shortly entitled Virtual Asset Service Providers Amendment Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. The Virtual Asset Service Providers Amendment Bill 2024 has been given a second reading.
Information and Communications Technology Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services. I believe I can be forgiven for that one. I recognize the Honourable Minister for Plahi.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled the Information and Communication Technology Validation Bill 2024.
The bill has been duly moved. Does the Honourable Minister wish to speak thereto?
Yes, Mr. Speaker. Mr. Speaker, honourable members, I stand before you today with a bill that addresses the bedrock of our nation's economy and digital authority, the Information and Communication Technology Validation Bill for 2024. The bill provides the collection of ICT fees has always been a valid, but notwithstanding the fact that it was not affected in the necessary regulations as prescribed in the ICT Act. The ICT sector is a pillar of the national economy. It has come with to communicate on how we conduct our business and ultimately how we engage as a society. Yet that is still even innovation and requires regulations. By validating the past collection of license fees, we are reaffirming that as a government, we do not shy away from acknowledging the correction of administrative oversights. Honourable members, Clause 3 and 4 are of particular importance. Clause 3 endorses the license fees charged by paid to and collected during a period of commencing on the 5th of August 2003, and ending on the 15th of January of 2017. And the license fees charged by and paid collected during the period commencing on the 16th of January 2017 and ending on the commencement of this Act. Through Clause 4, the protection is provided to the individuals who have been executing these regulations, except where actions were in bad faith. It is crucial for us to support our public servants who diligently enforce our laws, providing them with the protection necessary to fulfill their duties without fear of future legal actions. Mr. Speaker, this bill paves the way for a future where our ICT sector can continue to thrive under the framework that is clear and accountable. Let us collectively take hold of the opportunity to reinforce our legislation and regulatory commitments. Honourable colleagues, let us support the bill and ensure that the continued prosperity of our nation and our people. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? The Honourable Member for Bordentown West.
Thank you, Mr. Speaker. I just rise to, I guess, add my 2 cents to this bill, that it's regrettable to some extent that it's being bought, and the contribution made earlier in an earlier debate by the member for Georgetown East in terms of these validation bills says something. But, Mr. Speaker, it also raises a bigger issue, which is that of a culture, where somehow people believe that it's okay to make money in this country, and the little that the government charges via direct taxation, or in some cases directly, it becomes an issue. And I looked earlier, Mr. Speaker, at the government's amount of money collected from ICT fees for 2022 and 2023, and it was just over 18 million CI dollars. But when you go to the ICT website, Mr. Speaker, and you see the amount of turnover for 2022 and 2023 from the ICT sector, it was 327 million CI dollars. So a sector that grosses $327 million in 2-year period, and the country only collects $18 million in fees from it. And then on top of that, Mr. Speaker, if you go and you look at ESO's website and you go to look at the calculation of gross domestic product, where they actually do a good job in terms of calculating both in terms of consumption or otherwise, and you see the profit that is buried inside that number, and the number for 2022 that, if memory serves me right, was in excess of $50 million worth of profit in that industry. So, Mr. Speaker, it is an industry that makes good money. But the reason why I'm actually highlighting this issue, Mr. Speaker, is also for the fact that the capital investment, which is also included in the ESO's calculation, is quite low. And when you factor in the necessity now of the Maya 1 cable coming to the end of its useful life next year, and you also bear in mind that the other cable that connects Cayman to the world, which is the Cayman Jamaica Fiber System, CGFS, literally came to its end of useful life, even though it's still functional, in, I think, 2021 or thereabouts. It says something about the industry in the sense that there is a culture that needs to change. And, Mr. Speaker, for full disclosure, I have, in a previous life, worked for 2 telecoms companies, and is acutely aware of the true cost of terminating a call. And I will leave it with this, Mr. Speaker. At a time when Cayman Wireless was charging $1.50 CI per minute to make calls to the United States in the middle of the day during peak hours, the cost to Cayman Wireless to terminate that call in the United States was 2 cents US. Let me say that again, Mr. Speaker. They were charging $1.50 CI for a cost to terminate in the US of 2 cents US. This is the culture within that industry. And when you see now, Mr. Speaker, that the people of this country, the taxpayers of this country, have to go and literally find money or find resources to put in another cable connection, another undersea cable to connect Cayman to the world. And the people have to find this money, despite these companies for decades making millions of dollars of profit in Cayman. The culture needs to change. And I'll just leave it at that. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, I'll invite the Honourable Minister for Planning, Agriculture, Housing, Infrastructure, Transport and Development to exercise his right of reply.
Thank you, Mr. Speaker. I just want to thank the honourable members of the House for their full support. I'd just also like to thank the team and the Administrator, Chief Officer Eric Bush, and the members on the off-reg board for all of their support going forward, and from here on out, and the members of off-reg also. Thank you so much.
The question is that a bill shortly entitled Information and Communications Technology Validation Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. The Information and Communications Technology Validation Bill 2024 has been given a second reading. The House will now resolve itself into committee for consideration of the bills. Please be seated. The House is now in committee. With the leave of the House, may I assume that as usual we should authorize the Honorable Attorney General to correct minor errors and such like in these bills. Would the clerk please state the first bill and read the clauses?
Banks and Trust Companies Amendment Bill 2024. Clause 1, short title and commencement. Clause 2, amendment of Section 6 of the Banks and Trust Companies Act 2021 revision, application to be made to authority. Clause 3, amendment of Section 27 of the Banks and Trust Companies Act 2021 revision, regulations. Clause 4, transitional. Okay.
That's all.
Mm-hmm.
The question is that clauses 1 through 4 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 4 stand part of the bill.
A bill for an act to amend the Banks and Trust Companies Act 2021 revision to provide that the application fee for the grant of a license is non-refundable and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill.
Companies Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, insertion of Section 29A in the Companies Act 2023 revision, name reservation. Clause 3, repeal and substitution of Section 159. Company, creditor, or member may apply to court for company to be reinstated. Clause 4, insertion of Section 199A, fees for administrative services. Clause 5, repeal and substitution of Section 200, express fees. Clause 6, amendment of Section 283, regulations. Clause 7, amendment of Schedule 5 fees. Clause 8, validation of payment and collection of fees. Clause 9, orders of determinations by court not affected.
The question is that clauses 1 through 9 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 9 stand part of the bill.
A bill for an act to amend the Companies Act 2023 revision to provide for applications for name reservation, to provide for the charging of fees for administrative services, to expand the list of transactions in respect of which express fees may be paid, to validate certain revenue collection actions of the registrar, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill.
Companies Management Amendment Bill 2024. Clause 1, short title and commencement. Clause 2, amendment of Section 5 of the Companies Management Act 2024 revision, application to be made to authority.
The question is that clauses 1 and 2 do stand part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. Clauses 1 and 2 stand part of the bill.
A bill for an act to amend the Companies Management Act 2024 revision to provide that the fee for an application for a license is non-refundable and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The title stands part of the bill.
Exempted Limited Partnership Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, insertion of Section 5A in the Exempted Limited Partnership Act 2021 revision, name reservation. Clause 3, insertion of Section 12A, fees for administrative services. Clause 4, repeal and substitution of Section 13, express fees. Clause 5, amendment of Section 36, dissolution. Clause 6, amendment of Section 41, deregistration pursuant to partnership agreement. Clause 7, amendment of Section 42, registration of foreign limited partnerships. Clause 8, amendment of Section 48, regulations. Clause 9, validation of the Exempted Limited Partnership Regulations 2014. Clause 10, validation of payment and collection of fees. Clause 11, orders or determinations by court not affected.
The question is that clauses 1 through 11 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 11 stand part of the bill.
A bill for an act to amend the Exempted Limited Partnership Act 2021 revision to provide for applications for name reservation, to provide for the charging of fees for administrative services, to expand the list of transactions in respect of which express fees may be paid, to introduce new fees, to validate the Exempted Limited Partnership Regulations 2014, to validate certain revenue collection actions of the registrar, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill.
Insurance Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, amendment of Section 4 of the Insurance Act 2010, licenses. Clause 3, amendment of Section 7, license renewal fees. Clause 4, amendment of Section 28B, registration of exempted company as portfolio insurance company. Clause 5, insertion of Section 39A, waiver or reduction of fees by cabinet. Clause 6, validation of collection of annual fees and surcharges from portfolio insurance companies. Clause 7, orders or determinations by a court not affected. Clause 8, transitional.
The question is that clauses 1 through 8 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 8 stand part of the bill.
A bill for an act to amend the Insurance Act 2010 to provide that the application fee for an application for a license or for registration as a portfolio insurance company is non-refundable, to provide for the payment of annual fees by persons registered under the Act, to amend the provisions relating to the registration of exempted companies as portfolio insurance companies, to validate the charging and collection of annual fees in respect of portfolio insurance companies, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill.
Limited Liability Companies Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, amendment of Section 46 of the Limited Liability Companies Act 2023 revision, merger and consolidation. Clause 3, amendment of Section 50, merger or consolidation with exempted companies. Clause 4, amendment of Section 51, merger or consolidation with foreign companies. Clause 5, amendment of Section 56, conversion of an exempted company to a limited liability company. Clause 6, insertion of Sections 59A and 59B, administrative services, express fees. Clause 7, validation of payment and collection of fees. Clause 8, orders or determinations by court not affected.
The question is that clauses 1 through 8 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 8 stand part of the bill.
A bill for an act to amend the Limited Liability Companies Act 2023 revision in order to provide a statutory basis for the registrar's collection of fees for several of the general registrar's services, to validate certain previous revenue collection actions of the registrar, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill.
Limited Liability Partnership Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, amendment of Section 37 of the Limited Liability Partnership Act 2023 revision. Deregistration pursuant to partnership agreement. Clause 3, insertion of Sections 45A and 45B, administrative services, express fees. Clause 4, validation of payment and collection of fees. Clause 5, orders or determinations by court not affected.
The question is that clauses 1 through 5 stand part of the bill. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 5 stand part of the bill.
A bill for an act to amend the Limited Liability Partnership Act 2023 revision in order to provide a statutory basis for the registrar's collection of fees for various services, to validate certain previous revenue collection actions of the registrar, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill.
Monetary Authority Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, general amendments to the Monetary Authority Act 2020 revision, references to parts. Clause 3, amendment of Section 46, regulations. Clause 4, repeal and substitution of Schedule 2, fees. Clause 5, validation of payment and collection of fees. Clause 6, orders or determinations by court not affected. Clause 7, transitional.
The question is that clauses 1 through 7 stand part of the bill. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 7 stand part of the bill.
A bill for an act to amend the Monetary Authority Act 2020 revision to provide for the making of regulations prescribing the charging of fees for administrative services provided by the authority to persons registered under any of the regulatory laws, to provide that fees may be prescribed as non-refundable, and to repeal and replace Schedule 2, to validate certain revenue collection actions of the authority and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill.
Mutual Funds Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, general amendments to the Mutual Funds Act 2021 revision, references to parts. Clause 3, amendment of Section 4, regulated mutual funds. Clause 5, amendment of Section 29, authority to administer this act. Clause 6, insertion of Section 36A, waiver or reduction of fees by Cabinet. Clause 7, validation of payment and collection of fees and of returns. Clause 8, orders or determinations by court not affected. Clause 9, transitional.
The question is that clauses 1 through 9 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 9 stand part of the bill.
A bill for an act to amend the Mutual Funds Act 2021 revision to provide for the charging of fees for certain transactions, to provide that the application fee for a mutual fund license is non-refundable, to validate certain revenue collection actions, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill.
Partnership Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, amendment of Section 2 of the Partnership Act 2024 revision, interpretation. Clause 3, insertion of Section 49A, name convention. Clause 4, insertion of Section 54A, administrative services. Clause 5, repeal and substitution of Section 55, express fees. Clause 6, amendment of Section 56, regulations. Clause 7, validation of payment and collection of fees. Clause 8, orders or determinations by court not affected.
The question is that clauses 1 through 8 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 8 stand part of the bill.
A bill for an act to amend the Partnership Act 2024 revision to provide for the name convention for limited partnerships, to provide for the registrar's collection of fees for various services, to validate certain revenue collection actions of the registrar, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The title stands part of the bill.
Private Funds Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, amendment of Section 6 of the Private Funds Act 2021 revision, application to be registered. Clause 3, amendment of Section 11, authority to be informed of changes. Clause 4, amendment of Section 14, annual return. Clause 5, validation of payment and collection of fees. Clause 6, orders or determinations by court not affected. Clause 7, transitional.
The question is that clauses 1 through 7 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 7 stand part of the bill.
A bill for an act to amend the Private Funds Act 2021 revision to provide for the charging of fees for certain transactions, to provide for a non-refundable application fee for an application by a private fund to be registered under the Act, to validate certain revenue collection actions, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The title stands part of the bill.
Securities Investment Business Amendment and Validation Bill 2024. Clause 1, short title and commencement. Clause 2, amendment of Section 2 of the Securities Investment Business Act 2020 revision, interpretation. Clause 3, amendment of Section 5, requirement for a license, registration, deregistration, and fees payable. Clause 4, amendment of Section 6, application for a license. Clause 5, amendment of Section 11, regulations. Clause 6, amendment of Section 16, powers and duties of the authority. Clause 7, validation of payment and collection of fees. Clause 8, orders or determinations by court not affected.
The question is that clauses 1 through 8 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 8 stand part of the bill.
A bill for an act to amend the Securities Investment Business Act 2020 revision to provide for fees for deregistration, to provide for fees for the filing of material changes by registered persons under Section 5, to provide for fees for restricted licenses, to provide for certain new definitions, to provide for the validation of fees collected by the authority, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The title stands part of the bill. Honorable members, I'm going to take a 15-minute suspension to allow the Premier and her team to consider the proposed amendment to the Virtual Asset Service Providers Amendment Bill 2024, given the short notice that they've had to deal with the matter. So if we could all make a real effort to be back in our seats, if you need to leave them at all, at 5:15. The committee will suspend until 5:15. That was a rather long 15 minutes. But proceedings of committee are resumed.
Virtual Asset Service Providers Amendment Bill 2024. Clause 1, short title and commencement.
The question is that Clause 1 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 1 stands part of the bill.
Clause 2, amendment of Section 2 of the Virtual Asset Service Providers Act 2024 revision, interpretation.
I have received notice of an amendment to the bill, to Clause 2 of the bill, and I have given the Honorable Member for West Bay South leave to move the amendment. Would he do so now, please?
Thank you, Mr. Chair. In accordance with the provisions of Standing Order 52, subsection 1 and 52, subsection 2, I, the Honorable Andre Ebanks, elected member for West Bay South, give notice to move the following amendments to the Virtual Asset Service Providers Amendment Bill 2024. 1, paragraph 1 of the amendment, that the bill be amended in Clause 2 as follows. A, by inserting in the appropriate alphabetical sequence the following words in subclause small a, small Roman numeral 1, quote, issuance of virtual assets or virtual asset issuance, end quote. Paragraph B of the amendment, by inserting in the appropriate alphabetical sequence the following definition in subclause little a, little Roman numeral 3, quote, issuance of virtual assets or virtual asset issuance means the sale of the newly created virtual assets to the public in or from within the islands in exchange for fiat currency, other virtual assets, or other consideration, but does not include the sale of virtual service tokens, nor, for the avoidance of doubt, equity interests as defined under the Mutual Funds Act, investment interests as defined under the Private Funds Act, in accordance with any statement of guidance or rule that may be issued by the authority, end quote.
The amendment has been duly moved. Does any member wish to speak thereto?
I do, Mr.
The
Chair.
Honorable Member for Bodden. Well, I'm going to try to observe proper protocol in committee. In committee, members are called by their names. Mr. Ebanks.
Thank you, Mr. Chair. Mr. Chair, as I alluded to in the debate in the second reading of the bill, we have well, first of all, thank you, Mr. Chair, for allowing this beyond the standard notice under the standing orders. Thank you for that, Mr. Chair. As I alluded to in the debate, I believe we have a unique opportunity to answer a member's search for growth that was said in a number of debates on a number of bills this evening. And I recall that this was one of the issues when the bill was out for consultation between industry, the primary regulator, the monetary authority, and the ministry, whereby we are, as a jurisdiction, losing market share in the form of investment funds that are now tracked by blockchain technology as opposed to traditional electronic central registers. The effect of that is that not only are we losing market share to competing jurisdictions, we're then not keeping up with the innovation in the fund sector, and then we're not also creating an opportunity for growth. The risk by not acting today is that this trend continues over time, and the traditional technology gets overtaken by the new technology, and funds just continue to set up in another jurisdiction rather than where they properly should be. The concern was not as large, Mr. Chair, when it was smaller asset managers, but now that some of the largest private equity houses in the world, which are naturally our clients, have moved to this technology. As the Premier rightly said in one of the debates on the bill, anything can happen next month, the month after, where we might not have this unique opportunity to assist industry, where there is little downside. There may be consequential amendments that may have to be made, but ultimately, the monetary authority, as far as I know, is in principle in agreement, primarily because they still have industry practice rules that they can issue a guidance to limit the scope for unintended consequences. So with that, Mr. Speaker, I would move that this House continue to assist the country's key financial services, financial driver, and continue to innovate the bread and butter of our financial services, which is investment funds.
Does any other member wish to speak? The Honorable Premier and I'm still going to call you Premier, the Honorable Premier.
Yes, okay. Thank you, Mr. Chair. Mr. Chair, thank you for giving the government an opportunity to consider this last-minute amendment. We've considered it, we've consulted with our legal team, as well as our technical team, as well as the regulators, and the consensus is that in principle, it is agreed, but the regulators' position have not changed from when the former minister was there, and that the industry, from what I'm reliably informed, had agreed with it and saw the significance, but the regulators wanted more time to consider it because of the possible unintended consequences, in particular as will relate to the Mutual Funds Act and the Private Funds Act. And so the government would give the commitment to reconvene, subject to members coming to make a quorum in January, which would give the regulator time to continue her negotiations and getting opinions of their legal team to ensure that we get it right. The government wishes in principle to support it, but not at this particular time. We'd be much happier to take the advice of our regulators at this time, who are not in a position to agree to it based on the advice that I've obtained during the break.
Thank you. Does any other member wish to speak? Mr. Bush? Mr. McKeever Bush?
No, Mr. Honorable. Thank you very much, Mr. Chair. Mr. Chair, did I understand the member for West Bay West that there is business that south? Oh, no, I know him good, him a cousin. That there is business, he's saying big business, that could fly away because we don't put this in today. And how long did you know that?
Mr. Ebanks.
As I mentioned in my opening remarks, this was part of consultation with industry. I can't speak as to why it didn't feature in the bill as published, but this was not something new, and it's not a question of business may fly away. The concern of industry is that it is flying away presently.
And you had that knowledge before?
The ministry, SEMA, and industry all had the knowledge before, and it did not feature.
Did you, as the minister who left the government, did you know that business was flying away with this piece of legislation to come, and was not yet clamped down, made to where it could have been understood by SEMA, our regulator?
Mr. Bush, could I ask you to direct your responses through the chair?
Mr. Chairman, okay. But you know we always talking to you.
Let's keep it civil.
Through you, Mr. Chair, I've answered the member's question already. Yes, all parties that I described in my opening remarks were aware. All parties were consulting on the provision. All parties knew they had time to be able to consider it, and that's why all parties are in agreement in principle.
Mr. Chairman, to the minister,
Mr. Bush,
or the member, did SEMA say to you that they had concerns about what was being proposed?
SEMA's concerns, as I understood it at the time, is that they wanted to be able to issue a statement of guidance or rules in order to enact it, which is what's in the clause.
And so far, that has not been able, because that's what we're being told by our regulator, whom you always said we should follow, and all this legislation we're doing and all this other stuff we're doing, we're talking about we should follow the regulator. And all the premier is saying, let us take some more time. That can't be that long, but we need to give the regulator, whom you all, build up to be the best thing in the world, which we know has done well for the country.
In response, Mr. Chair, the regulator would be given enough time because they have an opportunity to draft the statement of guidance or the rule. So there isn't any doubt that we're listening to the regulator, which is why it's included in the clause.
The chairman.
Mr. Bush, I don't think we're going anywhere with this. It's
No,
back and
no,
forth.
we're not, probably, but I do need to say some things, Mr. Chairman.
Okay, keep it brief.
And yes, if they would do the right things, yes. Mr. Chairman, if our regulator, and I'll repeat it, has put forward their position, I don't see why this House, who claims that we are going and following what our regulator tells us to do, that is right. And they say they needed more time to get the matter straight, to get it to see whether there's more legislation that's going to impact. We have been told now that it will impact at least 2 more pieces of legislation. We have been told that by the regulator. So what are we going to do? Pass this now, Mr. Chairman? Are we going to pass this now then while we know that it's going to affect 2 other pieces of legislation? What do we do then? We can wait till January then or you want to come by Christmas Day, I don't know, to pass fix those 2 pieces of legislation?
Mr. Chair, just briefly acknowledging that I'm heartened that Mr. McKeever Bush would like to observe regulation and would like to observe the monetary authority, which seems contrary to his statements in the House previously. So I'm heartened by that.
No. I can take that, Mr. Chairman. I'm not going to take that. He must withdraw that. He must withdraw that. I stand by regulation. I'll put regulation in place, and people that are crowning it now objected then. So don't come tongue-in-cheek about, see that I like regulation. I like it as good as you. I'm not a lawyer, but I've been here 40 years, and I've seen it now, put it in place, and this country has benefited from it. So don't talk crap to me.
Honorable members, please, now, this is not at all constructive. This is an important matter, and people have differences of view, but there's no need for this kind of, because it's not, we're not discussing anything now. Let me not say anymore. Does any other member wish to speak?
Mr. Chairman.
The Honorable Leader of the Opposition.
Thank you, Mr. Chairman. Mr. Chairman, we have, you just said that this is an important, very important piece of legislation and impactful, could be very impactful in a positive way as far as the development of the industry. But there also could be unintended consequences if not thought through properly. We on the official opposition, and others are free to speak, but obviously we have our first sight of this amendment was this afternoon, just before the break, and we've had an opportunity to hear from the mover of the amendment, Mr. Ebanks, and then we had an opportunity to hear from Honorable Premier and the Attorney General. And we are in a situation where, the authority, SEMA, is now saying, in principle, they're good with the language. And that obviously there's a breakthrough when it comes to the bit at the end there where it says that defined under the Private Funds Act in accordance with any statement of guidance or rule that may be issued by the authority. However, the authority, that being SEMA, have concerns that perhaps 2 other pieces or 2 other acts may be affected by it, and would like some time to review those along with this amendment to ensure that there are no unintended consequences. In our discussions with the Honorable Premier, it is felt that, and she will endeavor to have legal drafting along, and we got the same commitment from the Attorney General to look at the possibility, or they will endeavor to bring back all three amendments, the amendment to this act and to the two, should need be, to the other two acts that they feel would be impacted, God's willing, when or if we meet in January. Considering the time of the year, it's a challenge, but also considering the time of the year that company fees have been paid and persons are probably not considering these sorts of drastic moves. The business that we've already lost, business that has already that have already registered overseas, we've lost that. We are comfortable, and I am certainly comfortable, and I will do everything that we can to help the Premier to ensure that we see these amendments come back, including those with the other affected pieces, other affected acts. And so I think that is the position we're going to take, Mr. Chairman, because we have not had an opportunity to have any further insight on this and to have any other consultation on this. We have to follow the Attorney General and the Monetary Authority's lead on this.
Does any other member wish to speak?
Mr. Speaker,
Yeah,
Mr. Chair.
Mrs. Ebanks-Wilkes.
Thank you. I was just seeking clarification then that there is going to be a commitment that the amendments would be coming back at the next sitting.
Mr. Speaker, I'm happy to repeat what I said earlier on. Having spoken to my legal team, the technical team, including the regulators, they were okay with it in principle. The regulators wanted more time to deal with it, to speak to their own legal team, because they felt that there were perhaps could be unintended consequences with the Mutual Funds Act and the Private Funds Act in the first instance. And so, God's willing, we hope to convene Parliament again in January. And at that time, the government commits to bring it back to the House, to the Parliament, sorry.
Any other member wish to speak? Mr. Ebanks.
Thank you, Mr. Chair. Through you, Mr. Chair. That's an important question that Ms. Ebanks-Wilkes had to reiterate. I was only in the energized discussion with Mr. McKeever-Bush, just clarifying what I knew and who knew it and who knew it when. On the direct question of whether or not the House finds it more prudent, even though all parties are in principle, as long as we have the commitment that if the House should meet in either January or February to bring this back with any other consequential or connected amendments, that seems that can be acceptable for us. But I just caution the fact that this has been part of a long consultation. This is not a new issue. That's why I believe Sim was in principle comfortable. But I just want to be sure that this actually happens, because if we lose the opportunity, there could be unintended consequences the other way of more loss of business.
Mr. Ebanks, it seems to me that from the talk, from the statements members have made, that if you press ahead with this amendment, you're going to lose it. So the choice really at this stage is whether you wish to withdraw the amendment or whether you want to press it for a vote.
Mr. Chair, just to clarify my last statement, that's what I was indicating. I'm happy to withdraw now that Ms. Ebanks-Wilkes has had the Premier reiterate that this will be brought back with consequential amendments in the next meeting of the House within this administration. So I would hereby withdraw.
So I need you to move that motion. A motion to withdraw your motion.
Yeah. Mr. Speaker.
You don't need a seconder in committee. You can just do it yourself.
Mr. Speaker, I, Honorable Andre Ebanks, member for West Bay South, do hereby withdraw this committee stage amendment.
You need to move it as a motion.
And move a motion for the withdrawal of the committee stage amendment.
The question is that the amendment, the proposed amendment to Clause 2 of the Virtual Asset Service Providers Amendment Bill 2024 be withdrawn. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment.
Well, division?
Could you let me finish?
Thought you had.
So the notice of committee stage amendment, Virtual Asset Service Providers Amendment Bill 2024 is hereby withdrawn. Mr. William McKeever Bush. You wish to say something, sir?
It's on record that I have asked for division. Yes, that's what I would like.
Madam Clerk, can we divide?
Honourable Juliana O'Connor Connolly.
Aye.
Honourable Kenneth Bryan.
Aye.
Honourable Johanny Ebanks.
Aye.
Honourable Isaac Rankin.
Aye.
Mr. Bernie Bush. Okay. Honourable Dwayne Seymour.
Aye.
Honourable McKeever Bush.
To withdraw, definitely. Aye.
Honourable Joseph Hugh.
Aye.
Miss Barbara Connolly.
Aye.
Mr. Andre Ebanks.
To withdraw, definitely with my caveats.
Honourable Catherine Ebanks Wilkes.
Aye.
Mrs. Sabrina Turner.
Aye.
Honourable Heather Bodden.
Aye.
Honourable Wayne Panton. Aye. Mr. Moses Kirkconnell.
Aye.
Mr. Roy McTaggart.
Aye.
Mr. David White is absent. Mr. Christopher Saunders, absent.
Fifteen ayes, 1 abstention, 2 absences. The motion, well, I've said that already, but the motion is carried. The motion to withdraw is carried.
Clause 2. Amendment of Section 2 of the Virtual Asset Service Providers Act 2024 Revision Interpretation. Clause 3. Amendment of Section 3, Meaning of Virtual Asset Service Provider. Clause 4. Amendment of Section 4, Registration of License Required. Clause 5. Amendment of Section 5, Fees. Clause 6. Amendment of Section 6, Application for Registration. Clause 7, Amendment of Section 8, Application for Virtual Asset Service License. Clause 8, Amendment of Section 9, General Requirements for Virtual Asset Service Providers. Clause 9, Amendment of Section 10, Requirements, Virtual Asset Custody Services. Clause 10, Repeal of Section 13, Directions to apply for license under this Act. Clause 11, Repeal and substitution of Sections 14 and 15, Directions to apply for a license under another regulatory law. Notice by existing licensee. Clause 12, Amendment of Section 16, Waiver. Clause 13, Amendment to Section 19, application for a sandbox license. Clause 14, repeal of Part 4, decisions to license, register, approve issuances. Clause 15, amendment to Section 24, powers and duties of the authority. Clause 16, amendment to Section 25, enforcement powers of the authority. Clause 17, amendment to Section 26, direction to cease and desist. Clause 18, amendment to Section 27, revocation of license. Clause 19, amendment of Section 28, shares not to be issued or transferred without the prior approval of the authority. Clause 20, amendment of Section 30, appeals against decisions made by the authority. Clause 21, amendment to Section 31, audit of accounts. Clause 22, amendment of Section 32, duty of auditor. Clause 23, repeal and substitution of Section 33, entry and search of premises. Clause 24, amendment of Section 39, regulations. Clause 25, general amendments to the Virtual Asset Service Providers Act 2024 revision. Clause 26, transitional.
The question is that clauses 1 through 26 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 26 stand part of the bill.
A bill for an act to amend the Virtual Asset Service Providers Act 2024 revision, to amend definitions and provide new definitions of terms used in the act, to improve the supervision of certain virtual asset activities, to provide that the fees payable under the act are non-refundable, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill.
Information and Communications Technology Validation Bill 2024. Clause 1, short title. Clause 2, interpretation. Clause 3, validation of license fees. Clause 4, immunity. Clause 5, orders or determinations by a court. Clause 6, transitional provisions, pending and ongoing proceedings.
The question is that clauses 1 through 6 stand part of the bill. Those in favor, please say aye. Aye. Those against, no. The ayes have it. Clauses 1 through 6 stand part of the bill.
A bill for an act to validate the charging, payment, and collection of license fees during specified periods to validate certain actions taken in the charging and collection of license fees and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill. That concludes the consideration by this committee of the bills numbered 1 through 14 on today's order paper. The question now is that the bills be reported to the House. All those in favor, please say aye.
Aye. Aye.
Those against, no. The ayes have it. The bills will accordingly be reported to the House. The House is resumed. May I call on the Honorable Premier to move the suspension of Standing Order 10-2 in order that the business of the House may continue beyond the hour of interruption, which has passed some time ago. Please be seated.
Mr. Speaker, I wish to move the suspension of Standing Order 10-2 to allow the House to continue beyond the hour of 4:30 p.m.
The question is that Standing Order 10-2 be suspended in order that the business of the House may continue beyond the hour of interruption. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, Standing Order 10-2 is suspended.
Report on bills. Banks and Trust Companies Amendment Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that a bill shortly entitled the Banks and Trust Company Amendment Bill 2024 was considered by a committee of the whole House and passed the committee stage without amendment.
Madam Clerk. The Banks and Trust Companies Amendment Bill 2024 was passed without amendment and is accordingly set down for third reading.
Companies Amendment and Validation Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that a bill shortly entitled the Companies Amendment and Validation Bill 2024 was considered by a committee of the whole House and was passed at committee stage without amendment.
Accordingly, the Companies Amendment and Validation Bill 2024 has been duly reported to this House and is set down for third reading.
Companies Management Amendment Bill 2024.
Recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that a bill shortly entitled the Companies Management Amendment Bill 2024 was considered by a committee of the whole House and passed the committee stage without amendment.
Accordingly, the Companies Management Amendment Bill 2024 has been duly reported to this House and is set down for third reading.
Exempted Limited Partnership Amendment and Validation Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that a bill shortly entitled the Exempted Limited Partnership Amendment and Validation Bill 2024 was considered by a committee of the whole House and was passed at committee stage without amendment.
Accordingly, the Exempted Limited Partnership Amendment and Validation Bill 2024 has been duly reported to this House and is set down for third reading.
Insurance Amendment and Validation Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that a bill shortly entitled the Insurance Amendment and Validation Bill 2024 was considered by Committee of the Whole House and was passed at committee stage without amendment.
Accordingly, the Insurance Amendment and Validation Bill 2024 has been duly reported to this House and is set down for a third reading.
Limited Liability Companies Amendment and Validation Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. I have to report that the Limited Liability Companies Amendment and Validation Bill 2024 was considered by the Committee of the Whole House and was passed at committee stage without amendments.
Accordingly, the Limited Liability Companies Amendment and Validation Bill 2024 has been duly reported to this House and is set down for third reading.
Limited Liability Partnership Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you again, Mr. Speaker. Mr. Speaker, I have to report that a bill shortly entitled the Limited Liability Partnership Amendment and Validation Bill 2024 was considered by Committee of a Whole House and was passed at committee stage without amendments.
Accordingly, the Limited Liability Partnership Amendment and Validation Bill 2024 has been duly reported to this House and is set down for a third reading.
Monetary Authority Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that a Monetary Authority Amendment and Validation Bill 2024 was considered by Committee of the Whole House and was passed at committee stage without amendment.
Accordingly, the Monetary Authority Amendment and Validation Bill 2024 has been duly reported to this House and is set down for third reading.
Mutual Funds Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that the Mutual Funds Amendment and Validation Bill 2024 was considered by a Committee of the Whole House at the committee stage was passed without amendments.
Accordingly, the Mutual Funds Amendment and Validation Bill 2024 has been duly reported to this House and is set down for third reading.
Partnership Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Once again, thank you, Mr. Speaker. I have to report that the Partnership Amendment and Validation Bill 2024 was considered by the Committee of the Whole House and at committee stage was passed without amendment.
Accordingly, the Partnership Amendment and Validation Bill 2024 has been duly reported to this House and is set down for third reading.
Private Funds Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. I have to report that the Private Funds Amendment and Validation Bill 2024 was considered by Committee of the Whole House and at committee stage was passed without amendment.
Accordingly, the Private Funds Amendment and Validation Bill 2024 has been duly reported to this House and is set down for third reading.
Securities Investment Business Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that the Virtual Asset Service Providers Amendment Bill 2024 was considered by the Committee of the Whole House and at committee stage was passed without amendment.
Accordingly, the Virtual Asset Service Providers Amendment Bill 2024 has been duly reported to this House and is set down for third reading. Madam Clerk, did we miss one? I think we missed the Securities. Yeah, I thought so. Madam Clerk, just read the title again and
Securities Investment Business Amendment and Validation Bill 2024.
I recognize the Honourable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that the Securities Investment Business Amendment and Validation Bill 2024 was considered by the Committee of the Whole House and at committee stage was passed without amendment.
Accordingly, the Securities Investment Business Amendment and Validation Bill 2024 has been duly reported to this House and is set down for a third reading.
Virtual Asset Service Providers Amendment Bill 2024.
I recognize the Honorable Minister for Planning, Agriculture, Housing, Infrastructure, Transport and Development.
Mr. Speaker, I'm happy to report that. Oh, sorry.
Sorry?
No, you thought you had called in.
We did the virtual one already. We did it before we did the securities one. It's been done. Honorable Minister, proceed.
Thank you, Mr. Speaker. Mr. Speaker, I'm happy to report that a bill short title Information and Communication Technology Validation Bill 2024 was considered by the Committee of the Whole House and was passed at committee stage without any amendments.
Virtual Asset Service Providers Amendment Bill 2024.
I recognize the Honorable Premier and Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I have to report that the Virtual Asset Service Providers Amendment Bill 2024 was considered by a committee of the whole House and at committee stage was passed without amendment.
Accordingly, the Virtual Asset Service Providers Amendment Bill 2024 has been duly reported to this House and is set down for third reading.
Information and Communications Technology Validation Bill 2024.
I recognize the Honorable Minister for Planning, Agriculture, Housing, Infrastructure, Transport and Development.
Mr. Speaker, I'm happy to report that a bill, Information and Communication Technology Validation Bill 2024, was considered by the Committee of the Whole House and was passed at the committee stage without amendments.
Accordingly, the Information and Communications Technology Validation Bill 2024 has been duly reported to this House and is set down for third reading. Madam Premier, may I invite you to move the adjournment?
Once again, thank you, Mr. Speaker, and thank you for your indulgence of going past 4:30 so that we could have the important business of Parliament continued. I'd like now, sir, to move the adjournment of this Honourable Parliament until 10 a.m. on Wednesday, the 11th of December.
The question is that this House do now adjourn until 10 a.m. on Wednesday, the 11th of December. Those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. Accordingly, the House is adjourned until 10 a.m. on Wednesday, the 11th of December.